which is found to be forged. I said that I have not obtained the executive category certificate because I am in normal course. I got appointment. I have no exemplary category certificate. Co-directed for giving instructions at the motion stage. But kindly take it up, Malad. I'm without pay.
Okay, yeah.
Yesterday my mentioning was refused, but I could not produce the notice. Today I have given yesterday I have given notice and I have come up with a notice for only for the issue is for general transfer on special ground. The single teacher, it has been rejected. Subsequently, by dint of the order passed by this honorable court, 2 division main judgment that single teacher has no bar to transfer. That issue has been settled 2022. The writ petition is pending for waiting the division main judgment.
Upon mentioning, my lord, it is appearing before the lordship's list as item number 200, my lord. My lord, there is an urgency, my lord. My lord, there is a request from the honorable division bench, my lord, to give priority of the, since we are not enjoying any interim order, my lord. There is a memorandum, my lord, by which a panel has been prepared, my lord. My lord, we are eligible, my lord. In spite of our eligibility, my lord, the state government is giving appointment in the government college as also in the government aided college, the teachers who are not eligible, because we are according to the UGC's norms, my lord, we are, my lord, entitled, my lord, for the for upgradation, my lord. My lord may fix.
Upgrade করবে।
I'm grateful, my lord.
May I have your kind leave to mention a matter? My lord, this matter pertains to the petitioner is aggrieved by the rejection of the petitioner's prayer of it was heard by the coordinate bench of Arindam Mukherjee. I have annexed the
What is the urgency?
the urgency is that, my lord, on compassionate grounds, I was rejected for employment. And during the course of my father's tenure, I had also challenged the same order which had rejected my prayer for getting the job. So, my lord, it would be, if you would be kind enough for inclusion.
July month list দিন।
I'm sorry, my lord, for embarrassment of your lordship, my lord. My lord, kindly take it as to be mentioned, my lord.
To be mentioned, to be mentioned for another.
My lord, only for fixing up a date.
Okay, it would be given. It would be listed. Keep watch on the list. It would be given and on any date. Okay.
Well,
আপনি আপগ্রেডের ম্যাটারে ঢুকিয়ে রেখে দিন তারপর ঠিক।
I'm also affixing the order of the honorable division bench.
হ্যাঁ, আপগ্রেডের ম্যাটারে রেখে দেবেন। হ্যাঁ, সাপ্লিমেন্টারি লিস্টই রেখে হ্যাঁ, আপগ্রেডেড ম্যাটার। হ্যাঁ, yes. Now call the list.
Item number 1.
My lord, in item number 1, I am for the petitioner. My lord, I am praying for release of this matter because
Release of this matter.
because the matter was dismissed by His Lordship Honorable Justice Tirthankar Ghosh. Thereafter, we filed a recalling. By mistake, it has been mentioned in before your Lordship, my lord. Recalling can be done only by His Justice Ghosh, my lord. 2019, it was dismissed on merit, my lord.
Based on the prayer made on behalf of the petitioner, the matter stand released from my list.
Item number 2.
ডিসমিস আবার এটা দিয়েছেন, এটা কি কোনো ভুল হয়েছে? এটা কি কোনো ভুল হয়েছে? আনন্দ কুমার রায় ভার্সেস মিলন। ও এই দেখুন, WPF সিও হবে।
Item number 3. My lord, 3 I appear for the petitioner. My lord,
You are appearing for the petitioner.
I have informed them before mentioning. I have informed them today morning through WhatsApp, through email.
What is the matter about?
My lord, I have been allotted a contract for construction of classroom of a primary school, government aided, at Malda, Manikchok. Now, my lord,
The bill was raised to the tune of 7 lakhs and 66,000 and odd, out of which 1,95,000 has been paid to me till date. The rest of the amount, 5,27,000, has been defalcated by the headmaster. Well, kindly have a look at the earlier order dated 24th of June, first page, very first page. 24th of June 2022.
Page number?
No, order passed by my Lord Justice Mousumi Bhattacharya.
Yes.
Kindly have a look at the last line. Fund has been defalcated by the headmaster. Fund was allotted through check, government check, defalcated by the headmaster. They sought for 1 week time. Thereafter, matter could not be listed, despite mentioning. As on date, 5,27,000 is due. And the headmaster could not appear, did not appear, chose not to appear before on the earlier occasion also, before this honorable court.
Ansari Qureshi for the state.
Anwari Qureshi.
Anwari
Qureshi.
Qureshi.
Today morning, I have sent message through WhatsApp, screenshot of this matter. Sent email that the matter is listed as item number 3 before your lordship. No response, chose not to appear.
Okay, you give a written intimation that the matter would be taken up tomorrow. Okay.
My lord.
Not today. Just not today. The matter would be taken up tomorrow.
Item number 4, time for the petition.
Yes.
The affidavit of service. This matter pertains to
I get to for the West Bengal Information Commission.
Yes.
the administration, Your Lordship, there was a direction upon the commission to produce a report with regard to pendency of the second appeals, which I have prayed for expeditious hearing in this petition, Your Lordship.
Of the appeal filed before
The second appeal authority, that is the Information Commission.
Information Commission.
Not report exactly, my lord. On the last occasion, I said that his appeals were disposed of by the commission. Your lordship directed me to take instruction whether it is correct, and if it is, the order of the commission. May I place the order of the commission?
Also, may I get a copy
Yes,
of
yes, certainly.
What is the number of the appeal?
My lord, all his appeals, my lord, he had, my lord,
Oh.
8 appeals.
There is no
But if you
specific
lordship kindly
number.
see, all his appeals were taken up together. And he himself, my lord, prayed for that, the analogous hearing, my lord.
Oh. So, in view of such, the writ petition is disposed of?
Lordship,
No order is
Lordship,
because
I have to take instruction, Your Lordship, whether this.
no, what is
Press
such?
further action. He can
Huh?
always,
What is such?
whatever he
Was-
wants to do on this.
Lordship, kindly, Your Lordship. Let me come back because this was not informed to me, Your Lordship.
Whether
Kindly-
he will tell lie in the court.
Lordship, no, I am not saying that.
One learned advocate
I am
never.
not saying that, Your Lordship, but Your
I-
Lordship, kindly give me some.
Huh?
Copy of the disposal order
Huh?
is to be given to me also as a Howrah Corporation.
All 8 pending second appeal, complaints such and
There is
such,
no
pending
second appeal has been mentioned, Your
for
Lordship.
disposal, 6
Sir, my lord, list
are
with the
against
notices
our
and
reason for eto. Acha.
Lordship, kindly comes to paragraph number 10, Your Lordship. Filing of such a large number of RTI application by Sri Sardar is against the very spirit of RTI Act and is covered by the judgments of the Honorable Supreme Court and the Honorable High Court as mentioned above. Moreover, filing of 22nd appeals complaint is nothing but in a way coercing or intimidating the government officials and trying to clog the system and prevent the public authorities from discharging their normal public duty. Sri Sardar is advised to use IT Information Act in future as per the aims and objectives of the Act and direction of the Honorable Supreme Court and Honorable High Court given in this regard. Your Lordship, can this be stated, Your Lordship? Appeal is my statutory right. How can this be stated?
Whatever it is, my lord, it's a composite
What
order.
are paragraph 12?
It is therefore ordered that all the 8 appeals complaints submitted by the Sri Utpal Chatterjee.
It will be, my lord, Wajid Ali Sardar, there is a corrigendum also, my lord. এটা একটু দিয়ে দিন।
Lordship, let me come back, Your Lordship, because Lordship, so far my instruction is concerned, Your Lordship, on the same date, Howrah Municipal Corporation also asked for hearing, and they also, Your Lordship, called the petitioner in their office on the same date, on the same time, Your Lordship. This is my instruction. Your
আচ্ছা আপনি লিখুন, the present petition has been prepared seeking a direction upon the concerned repenting the
Commission, lordship.
দিন তাড়ানো দিয়ে নে। Documents are submitted on behalf of the commission. আচ্ছা এটা ডিডি none appears nor has any accommodation been sought for
I've been informed by Mr. Tanay Chakraborty's clerk that he could not come to court today due to a death in the close relative, Lordship. Lordship, I'm praying for not this week, Lordship.
Okay, not this week. Yes, এটা দুটোই আছে এবার দেখুন রিটার্নেবল ম্যাটার কেউ নেই 19 হ্যাঁ
Lordship paying for short passover.
why
Mr. Surya Bandyopadhyay appearing on behalf of this matter and
Let me start, my lord.
Here for the respondent, Mrs. Mike is reading it through online.
Lord, in this matter, my lord,
yes
my lord, in this matter, my lord, I beg to appear on behalf of the respondent 4 and 5, who are
Yes.
the owner and builder.
yes
My lord, my alignment sought for passover, my lord, but what I am submitting before your lordship, my lord, let it be taken up Friday if it is possible, my lord. Can it be taken up on Friday, my lord?
according to the
I went,
convenience
my lord, told your lordship, my lord, I want to remain present before your lordship to move the matter. So your lordship, please to consider my prayer. And it was fixed.
you are for
I
municipal
am for the respondent number, private respondent 4 and 5.
I am for the municipality.
now days has come gradually when you want to do judge will see it at that time
Yes, lordship, Friday I shall remain present, you know.
and according to
physically.
the description of the learned advocate the matter will be taken up by the court.
No, your lordship, I am not saying that. Subject to your lordship kind consideration. I am not saying that. This is my
Okay,
prayer
as per
before your lordship.
direction of the
This is my prayer, you know. I cannot say any but honorable
Fine.
court to take up any according to my own
come on
accord.
Friday,
That cannot
what can
say.
The matter remain its position.
okay the matter is will suppel and disappeal. Okay, returnable matter one day it would be placed at the top.
Press this application.
Hmm.
Whenever I would like to press this application. When I am suffering.
You are not suffering at all. It has already been
Friday,
closed matter. Still, my lord, I cannot stand on the way in early hearing. My lord, your lordship kindly take it up.
okay, come on Friday to দিয়ে দেবেন এটা নাকি Friday
I am grateful deeply obliged to your lordship, Lord. I am grateful, Lord. I want to remain present before your lordship physically.
পরের সপ্তাহে না না আবার চেঞ্জ হবে আস্তে আস্তে হিয়ারিং ম্যাটার গুলো ধরতে হবে আপনার ইয়েগুলো কম্বাইন লিস্ট সব কটাই যাতে টাচ হয় সেই রকম ব্যাপারটা বুঝতে পেরেছি
Mainly on next Monday it may publish, you know, but your lordship.
okay not this week would be better.
Lord, I am praying before your lordship to fix up a date. Your lordship kindly, Lord, consider my prayer. Any date suits your lordship, Lord. I am.
ওকে ফ্রাইডে এটাকে আপনি ইয়ে করে দেবেন ফ্রাইডে একটা ইয়ে করে দিয়ে দেবেন হ্যাঁ ফ্রাইডে ওকে কাম অন ফ্রাইডে নেক্সট আইটেম নাম্বার 20
As your lordship, grateful to your lordship.
Item number 5 dismissed for default. Okay, file an application.
Last occasion, your lordship, as per your lordship direction.
Petitioner rejected from a petitioner was entitled to pension after during hearing. I mean, income pension. Who is appearing for the state? Upon Kumar Pal.
Yes, madam. Sapon Kumar Pal, my lord. They have filed a report, my lord, as per your lordship.
Whether report is on the record. Report, yes.
Yes. I filed the exception to the report, my lord. Kindly see my exception, my lord.
No, now you are receiving pension.
But they have miscalculated it. Well, I annex page 6 my exception my last pay salary 66,305. They have calculated. Kindly see their report kindly see their report.
Your case is that due to calculation, you are drawing lesser amount of pension.
They have filed a report on the basis of I have annexed their document last pay certificate
What they have stated in their report?
55,000. My is 66,000.
No, not on. It would not be on the gross.
Yes, ma'am. And also calculation.
It would be last drawn pay. That means basic pay.
Yes, ma'am.
It would be pension would be calculated subject to correction that on the basis of last drawn pay. That means basic pay.
But they did not come, your lordship direct them to calculate and submit a fresh report on the basis of the last pay salary.
No, they have filed already. They have submitted the report.
Calculate on the basis of the last pay salary. They have not, madam. Kindly see the report, madam.
You are employee of
the head teacher. Kindly see, madam. I face my case, madam. The petitioner retired service from the 28th February 2022. After 60 years from the head teacher, post of head teacher of the Varanagar covered basic school under the Jhargram West Circle. Head teacher in primary school, madam. It is their record, madam, not my record, madam. Direct them to submit press report, madam, on the basis of considering my exception, madam. Exception annexed, madam. I have annexed all the documents, madam. My last pay certificate and also, my lord, the kindly memorandum.
No, yeah, the office of sub inspector of school
Yes, madam.
detected that you have overdrawn an amount of rupees 2,12,000.
That was deposited. Kindly see, madam.
That has been deposited.
Yes. Kindly see my lead petition, madam. Kindly.
So what can be done? I am sending it to the who is the authority. Sending it to the authority concerned. Let them consider.
Consider on the basis of
Whether court will undertake the responsibility of making calculation.
Yes, madam. Your lordship, consider my exception. Considering my exception also. Their report and my exception, consider and take a decision, madam.
Who appeared on earlier occasions, Sopon Kumar Pal.
Or my lord, your lordship, fixed date, my lord, specific date and time, my lord, I inform my lord.
You have deposited the amount. And now you are drawing pension.
Well, kindly adjourn and I inform my date come, madam. Past it.
Okay, not today.
Not today, subject to stop, madam. He not.
No, you say that it is appearing any date. It may be taken up. Okay.
Subject to top, madam. At top, madam. Otherwise, my matter will not.
It is under the heading returnable matter hearing, it is appearing at the top. Mr. Shah, are you appearing in this matter?
My lord, I am for the district primary school council.
Huh.
What I have seen in the last ordership, my lord, order of your lordship, my lord, that your lordship directed the state respondents to file a report. Therefore, my lord,
Report has filed. Now he is claiming
yes,
that he has deposited the overdone amount.
my lord. Then, my lord,
I am sending it to the district inspector of
school for consideration.
Huh?
But then you will wait.
Adin.
Made by Mr. Pratik Majumdar, Lordship. I have a very innocuous prayer, Lordship. Lordship, it is a 2002 writ petition. The cost papers are not available with the Damodar Valley Corporation, Lordship. All the relevant pleadings are not available with the Damodar Valley Corporation, Lordship. Lordship, I will apply for the certified copy in the meantime. Lordship will kindly adjourn this matter for 2 months, Lordship.
Why?
Lordship, the papers are not available with the petitioner, Lordship.
So withdraw the writ petition. Withdraw the writ petition.
Lordship, we will proceed with the writ petition.
No, why? For 23 years. Why High Court will be, you are keeping just a dustbin?
Lordship will kindly.
Let it remain in the High Court. No.
Lordship will kindly adjourn the matter for 1 month, Lordship. I have applied for the certified copy, Lordship.
No, this week. This week.
This week I may not get, Lordship.
Your conduct is not does not inspire confidence that you are interested to pursue this matter. It is a matter of 2002. Why this court will keep pending? Going outside, you will say, look, for a matter of so many years are pending in the High Court.
We will kindly keep it as last chance, Lordship.
Last chance, not this week.
Lordship, kindly grant
Not
me 2
this
weeks,
week.
Lordship. Two weeks.
Not this week. If you want to do it. Otherwise, dismiss. Otherwise, dismiss.
Lordship will kindly pass an order to that effect, Lordship.
Whatever.
Lordship, that
it would be dismissed in the next week.
No, Lordship, that
order I can pass. That if the petitioner did not place his case properly, it would be dismissed on the next day.
Lordship will kindly pass an order to that effect that I will apply for the certified copy. Lordship will kindly grant me leave.
It is your headache. How you will present the court and which document you will present the court at the time of hearing, it is your headache. Court will not hear to assist you to collect the document.
Lordship, if you
what you have not been able to do for 23 years, you will not be able to do.
Lordship, may I indicate something, Lordship? Lordship doesn't pass an order, Lordship, giving me
the matter. Let the either dismiss the matter dismissed for default or anything. You do whatever you can do. Dismiss. It was dismissed for default on several occasions, I think. It is dismissed. You are not interested.
May I indicate one thing, Lordship? Lordship, in the event your Lordship.
What is the matter? You tell.
Lordship, we do not know, Lordship, because we have just.
That means keeping the matter pending, you are taking advantage.
Lordship kindly keeps it as last chance, Lordship. Your Lordship, if your Lordship doesn't pass an order giving me liberty to
against Pollution Control Board.
Yes, Lordship.
So you have done something. Pollution Control Board took steps which may have resulted in creating pollution in our atmosphere. Pollution Control Board issued some notice or order challenging the same you have come.
Lordship, we do not have the
and keeping the matter pending, you are going on taking advantage. You are running that unit or such and such, which is still creating pollution in our atmosphere. It is appearing. And you are showing the who is officer is going from Pollution Control Board. Look, the matter is pending. Don't do anything. The matter is pending High Court, in the High Court. High Court may snatch away your job. Don't do anything. Go home. You are doing for last 23 years.
Lordship, may I pray for it last time, Lordship? Lordship will kindly pass an order giving me 2 weeks time. In the meantime, Lordship will kindly record that let the petitioner apply for.
Only not this week. No.
Lordship, in the event the file.
अच्छा ये लिखूं तो अच्छा ये Petitioner is directed to intimate this order to the other non appearing respondents. Okay, yes. Come in the next slide. We shall see. Yes, next.
My lord has recorded 22. It's a matter of 2002,
Yes, 2002.
not 20.
I have seen 23 years.
For the petitioner.
Hmm.
I'm appearing late by me.
You also not with the brief. Not today. Yes. Not today. এটা হঠাৎ করে এসে গেছে তো
33.
23.
Respondents.
Elisha.
Yes, madam. On last occasion, your lordship was pleased to direct, consider the matter, and my lord, it will take time, my lord. Your lordship kindly adjourn for 8 weeks.
Whether it is a dispute between nominee and
Yeah, yes, yes,
Eh?
yes, my lord. Madam, there are not only that, my lord, there are 8 petitioners in one writ petition. Your lordship has order has been complied with only 6%. So, my lord, another 2% has to be complied with the order. Thereafter, my lord, at one order may be passed by the competent authority. That's why, my lord, it will take time.
to redress the grievances of the rest two petitioners.
My lord,
The
your
grievances of
lordship-
6 petitioners have already redressed.
Yes, madam. Your lordship has already been complied with by the 6 petitioners to give the documents, to produce the documents before the LIC authority. But my lord, 2 writ petitioners will not do till date. He has not given the documents. And my lord, competent authority, it will take time. that
So petitioner produced the relevant document.
6 petitioners.
Hmm.
Not
24.
24.
For the petition, I'm praying for only not to given. What happened on last occasion, your lordship was supposed to direct me to file my affidavit and reply. My reply is ready, but I find from my file that my office copy is not there. So only give me not to make it not today, tomorrow, my lord.
Okay, not today.
I'm grateful.
So I'm placing it under the heading hearing, not as a returnable matter. Okay. হ্যাঁ তাহলে যেগুলো হচ্ছে একজন চাইছে সেগুলো আর রিটার্নেবল ম্যাটারে লাগবে না, হিয়ারিং এ দিয়ে
It should go down in the list.
yes, go down the list. No,
Let the matter appear under the
give all the litigants equal opportunity.
only one day, my lord. Let the matter appear under the same meeting, my lord. May I come back on tomorrow, my lord?
Okay, it should go hearing. Okay. Next. 25.
I beg to appear for the petitioner, my lord. Under the primary grievances, my lord, non-availability of records from the court. My lord, your lordship, I beseech your lordship to kindly comes to the order
from the court.
From court, my lord, my case records went missing. An execution proceeding, my lord, went missing for several years, several representations. Your lordship, I beseech your lordship to kindly come to the order passed by this the other coordinate bench. My lord, your lordship kindly sees the order. A report was sought for, my lord.
এই ইয়ে করতে হবে না, বুঝলেন? আজকে তো আসছে, করতে হবে না, নাকি?
Order dated 14th of February 2020.
Should have filed a 227 petition under Article 227.
That was this is administrative side, my lord. Records went missing, made an application for reconstruction, and all steps, possible steps in terms of the rules, my lord, was made. But strangely, my lord, since there was a decree for eviction, it was going on, execution proceeded, police help cost deposited. At that juncture,
have you made application before the district judge or competent?
Yes, my lord, that is
before the concerned court. Who is this the concerned court?
My lord, this is my lord, civil judge, near division, Shialda.
For reconstruction you have made.
Even for reconstruction also it was made.
The concerned judge did not take any.
My lord, that it was saying there was a report has been sought for by the district judge, by this honorable court, the registrar on judicial side.
You are appealing for?
Is appealing for the state, my lord.
State what will do?
Because your lordship knows rules.
You should have filed an application under 227. It is fall within the supervisory jurisdiction of the High Court. Basically, regarding judicial matter, petition should not be entertained and should not be filed also.
Records went missing.
It is relating to the judicial business, business relating to the judicial matter, judicial function.
What is falling from your lordship, my lord, I bowed on, my lord. And record went missing. We made several representations, even applications.
File 227. That would be appropriate for him. What is the administrative side?
My lord, they should.
He will pass that order. He will pass the order for reconstruction in connection with a record.
My lord, lordship kindly sees the record suddenly went missing for several years. Several attempts were made, and my lord, no efforts were, my lord. Your lordship knows.
So what is the judicial review?
With such
you say that judicial review.
Your lordship knows how the.
No, the lordship does not know anything. There is a judgment of the Punjab High Court. The judge do not know. The judges do not know anything.
several representations.
There would be a precedent. Entertainment of this matter would be a precedent.
Well, they should, my lord, in terms of the earlier order, they should file a report whether.
It is a simple matter. You will file an application for construction. You will say that, yes, I am ready to supply all the document. That would be
Lordship
checked
kindly
by
comes
your
to-
other
Your
side.
Lordship kindly comes to page 50. That was done. It's a strange case, my lord, peculiar in circumstance, my lord. That was also done.
Oh, court is not against you.
My lord, that
And
application,
court won that your matter record should be reconstructed. Every day, many matters are being recorded, are being recorded.
petitioner wants, my lord, his matter to be, my lord. That was also not done. Your Lordship kindly sees that prayer was also paragraph 5. That is at page 50. That was also filed. That was not entertained because order sheets were not there. This is palpably, my lord, a denial of an opportunity to knock the door of justice.
The present petition has been prepared.
Item number 26.
Why I for the petitioner. There was a direction for to file affidavit for the GPSC, and GPSC now is filing today.
My lord,
To make a reply.
It was, my lord, it was affirmed on, my lord, December 2023. At point of time when the, my lord, division bench, my lord, allowed, my lord.
So you want time?
I want, my lord, I have to make a reply. Now we are serving this copy of the court today.
Yes, sir.
Acha, affidavit in opposition filed on behalf of respondent number 3 and 4.
Lordship.
Affidavit in opposition.
DPSC.
Item number 27.
Lord, I appear for the petitioner. ঠিক আছে ও বাবলার টাইম কোথায় বাবলার টাইম নেই তুই নেই তুই আগেরটা রেখেছিলি তুই সব মামলায় আছিস চল অ্যাপিয়ার করে তুই সবাইতে But on the last occasion when Lordship had taken it, I was not present.
You are not, the petitioner is
On the first occasion, Mr. Rai was not present. On the last occasion, I was not present.
Mr. D.L. Roy.
Yes, yes.
So give notice to him.
But I would also made the same submission.
Yes.
But may I submit one thing? Well, subject to Lordship, I know Lordship is a heavy bench. But on the next Tuesday, but I have another big, very problematic matter with your Lordship. But can we discuss on that day only?
The May 8th July is overburdened most probably. 8th July.
Because I have
8th July,
problem where I'm
since on Monday, monthly list will be published. 8th July, many matters has been.
I leave it to your Lordship.
9th July, 9th July, but 10th July, naki? 10th July কম আছে না? Oh, yes, দিন। এই আসুন। আচ্ছা, Hardal Anit advocate defending the petitioner, stop.
Item number 28 and appearing for respondent number 1.
But may I pray for some indulgence? But whichever way the order goes, my lord, this gentleman of the border security force is suffering from some time. My lord, on 10th July, can it be subject to your lordship's roster, my lord, at this somewhat at the top?
8th July.
10th July, well, cannot be on somewhere at the top, near the top, so that it can be taken.
It's fairly at the top. 8th July actually. Yes, next.
Your Lordship, Mr. Ujjwal Rai is appearing for the petitioner. He is on leg in court number 551. I am only praying for 1 day's accommodation, Your Lordship.
Lordship, may I submit, Lordship? Lordship, by one notification by central government, Lordship, the respondent number 1 bank along with 2 other banks has merged and formed a new bank called West Bengal Grameen Bank with effect from 1st of May 2025, Lordship. I am praying for an indulgence, Lordship, kindly allows me to file one affidavit to that effect, annexing that notification, Lordship, because the cost title will need to be changed, Lordship.
The liberty would be given to them.
May I file one affidavit, Lordship, annexing the document, Lordship, the notification, Lordship?
Affidavit only on this issue?
Yes.
Or affidavit to enter its petition?
No, only on.
So on this issue, you have filed affidavit to the writ petition?
No, Lordship.
So on this issue, you just produce the hand over the notification, he will change, liberty shall be given. For thus, of course, no affidavit is required to be filed. Okay,
I
if
will
you want
supply.
to file,
I will.
that means it is item number 28. It is Uttarbango Kshetriya Gramin Bank. It has been merged
With other two banks, Lordship, the new bank which has come into force is West Bengal Gramin Bank.
West Bengal Gramin Bank. Oh. So you change, you are representing the West Bengal Gramin Bank also.
Yes, Lordship. Yes.
আচ্ছা আপনি করুন তো, your name. To the important matter. Learned advocate for the petitioner submits that the affidavit in opposition filed on behalf of respondent number.
Respondent number 1.
Respondent number 1 has been received by the petitioner
1 and 2, my lord.
on 21st June. 21st June 2025. Stop. He submits that due to the reason beyond control of the petitioner, he could not prepare. The petitioner could not prepare the prepare the affidavit in reply. Stop. He prays for extension of time to file affidavit in reply. Oh,
The opposition.
The affidavit in
opposition to the amendment application as well as to the supplementary affidavit.
আচ্ছা তাহলে এ দুটো তো আচ্ছা affidavit in opposition affidavits in opposition to the application for amendment of the writ petition and to the writ petition itself. ঠিক আছে, two separate affidavits in opposition to the respectively filed on behalf of respondent number 1.
1 and 2.
taken on record.
Both respondents, my lord. One is to amendment, the other is to the supplementary filed by them. Writ petition, my
On
lord,
behalf
pleadings are
of the
complete.
respondents, ঠিক আছে, on behalf of the respondents, আচ্ছা, two separate affidavits in opposition. এবার colon. One, in respect of application for amendment of the writ petition, and the other in respect of the supplementary affidavit filed on behalf of the petitioner. Okay, নাম লিখে দেবেন। Yes, নাম লিখে দেবেন। Next.
Grateful, my lord.
Item number 30.
Item 30, my lord, I am appearing for the petitioners, my lord. Pursuant to my lord's order, I have communicated the order, approached my lord, the learned advocate Ranaji Chatterjee, my lord. But my lord, now he is not holding the brief, my lord, for KMC, my lord. The communication, my lord.
Serve directly to the respondent.
My lord, we have served several times, my lord. We have served directly to the my lord, the Kolkata Municipal Corporation Authority, my lord, having office.
Kolkata Municipal Corporation.
My lord.
You serve among Mr. Talukdar. Talukdar just here, Mr. Talukdar, you.
My lord, we have several times, my lord, we have communicated that.
Ask the court. Court has requested Mr. Talukdar to come.
Mr. Talukdar.
I shall engage him and regularize his engagement.
Kindly pass.
Mr. Talukdar, do you know Mr. Talukdar?
My lord, I will find.
Who usually appear on behalf of just he has appeared in one matter.
He appeared.
Yes. Not today.
My lord, kindly pass over. I will call him, my lord.
Okay, pass over.
My lord, I will call Mr. Talukdar. The communication letter, kindly. দাদা ওটা দিলাম, চিঠিটা যেটা দিলাম আমি ওটা দিয়ে দিলাম। Notes.
Item number 31.
May it please the lordship, my lord, I am for the petitioner. My lord, even on the last occasion, my lord, considering that they had prayed for the one-day accommodation, my lord, the last time also, my lord, the senior citizen petitioner has already died, my lord. He committed suicide because of the bank's follies. It's actually an indirect murder, my lord, not a suicide, because of the bank's unbridled greed.
So
they do not want to face
you
your
want
lordship, my lord.
the court to determine whether it is a suicide or murder? That is not my duty.
Lord.
Don't
My lord,
impose,
they don't want to face your
don't
lordship, my lord.
impose that burden upon the rich court.
My lord, they don't want to face your lordship.
Personal count.
My lord, every time, my lord, even on the last occasion, my lord, your lordship very well, very well. My lord, on the last occasion, your lordship verbally directed my learned friend to take appropriate steps. My lord, till date, nothing has happened. It's been more than 2 months. My lord had already directed verbally to take steps. Have you taken any steps? No, you haven't.
But tomorrow there shall be no difficulty.
Kindly keep it tomorrow.
Personal, general law,
Kindly keep it not.
personal, okay. Tomorrow you come, not today, what can be done? Court cannot force in this situation, okay, not today.
52.
I appear on behalf of the petitioner.
I appear on behalf of
filing
the
affidavit.
respondent, your lordship. I humbly apologize, the affidavit is not ready. Kindly give me a week's time, your lordship.
Okay, not today, what? Get ready,
Lordship, I assure you.
henceforth, court will, it is July 1st today. Henceforth, court will try to touch all the matter, even that combined list. Okay, and the matter will be reshuffled.
We'll keep that in mind, your lordship.
Today, returnable matter, tomorrow, again, upgraded matter will be placed at the top. Criminal matter will be placed at the top, part matter. Even the matter from combined list will be
Lordship, a week's time.
taken up, which can be done.
Lordship,
Kindly fixes a particular time, date by which
Not
they has to.
particular date. You want
But
to
filing the opposition.
today district
There was
court.
a direction, there
And
was a
date
direction
one.
on May 5th, your lordship.
Not today, not today. Try your luck when again the matter will be placed at the top. Returnable matter. Yes.
Any direction may be there, your lordship, otherwise.
Lordship will.
You are also not ready.
No, I am ready.
Huh?
I am ready, my brief is coming.
Where is your beef?
Brief is coming, your lordship.
Huh?
Because, in the
on his legs.
Yes, yes.
coming, your lordship.
Try your luck. I am trying to touch. Assist the court. I am trying
I'm
to
extremely
touch
grateful to
so that none can say that my matter is not being taken up. Okay. It would be reshuffled. One day partnered matter, one day assigned matter, one day returnable matter, one day upgraded matter in this way, one day from combined list, so that every one's matter can be touched. Okay.
Item number 33.
Yeah.
I am appearing
My
for the
lord,
petitioner.
my lord, in
Lord,
this
in
matter,
terms of your lordship's earlier direction or granting me liberty to file supplementary affidavit,
my lord,
Lord, I am filing this
my lord, may I
supplementary.
submit lordship? In this
On
matter,
the-
I am instructed to appear on behalf of the respondent, WBACDCL. Well, it's a matter of 2022 lordship. Just now, I have been instructed over telephone. My lord, give me at least 10 days time so that I can come back with proper instruction and lordship,
May I
this
tell-
is my
may I tell you, lordship, one thing. This is regarding non-payment of my bill during the period of 1 year in the year.
My lord, I am not on merit, lordship.
I'm just telling. I am also not going into merit. But why, my lord? I was required to file supplementary affidavit. Why I was, my lord, compelled to file the supplementary affidavit? I have annexed, my lord, to bring before your lordships one record that they have required me to submit the GST documents for the purpose of paying the bill. Therefore,
for the purpose of
paying my bill.
Achha.
Therefore, it is indirectly or directly, whatever it is, an admission that the bill is otherwise payable, provided or subject to their condition imposed that I should submit the GST particulars. My lord, this is a work I have completed in the year 2015 from January to December.
At that time, GST did not.
No, I have brought the book.
My lord, may I respectfully submit,
So take instruction and pay the bill without insisting for production of GST number. At that time, GST Act came into effect in 2017. 2017.
My lord, may I respectfully submit, lordship? My lord, may I respectfully submit, lordship? Kindly give me time so that
1 week.
My lord, 2 weeks time maybe.
No.
My lord, kindly two weeks time.
You find the lenient. Initially you paid for 10 days time. Thereafter you increasing 15 days. 1 week. Okay.
My lord, may I submit lordship on
Ajay.
my lord.
Affidavit service and
My lord, on
supplementary
next
affidavit.
Monday I shall not be available.
Learned
On 11th
advocate.
lordship, I shall.
Should file submit in the meantime, so that matter may be expedited.
Affidavit of opposition.
If they file a use any affidavit.
My lord, in that case, some more time.
no,
Otherwise,
no.
my lord, within a short period, lordship, I have to.
I'm keeping it 15 days.
Yes, lordship, kindly.
My
My
lord,
lord, give me some time, my lord.
Acha, list the matter after 2 weeks since. Acha, list the matter 2 weeks since.
Well, kindly
2
fix
weeks
it.
since the parties are directed to exchange. Are directed to exchange their affidavits in the meantime. Okay, next. 12 noon matter.
12 noon matter. On 15th, my lord.
7
On
to
15th.
15.
Kindly on date, 12.
No, 2 weeks
or
কবে?
16.
2 weeks আচ্ছা আপনি আজকে হচ্ছে
My lord,
16th, 15th or 16th.
এই 16 জুলাই ফাঁকা আছে? On 16 July, parties are directed to exchange their affidavit in the meantime. Okay, next.
At 12 noon, your lordship, it fell from your lordship.
Mr. Sen,
From your lordship.
on that date it would be taken out. Don't worry.
It fell from your lordship already. Already.
Don't 12 noon fixed, specially fixed matter now, which will be called now.
So returnable matter.
Okay. He had called the 12 noon fixed matter.
7 to 15, 12 to 6 matter.
16 I am for the state. Rest.
Milord, item 30, Milord. 30, Milord. Item 30. Milord, Mr. Talukdar, I find one Mr. Talukdar, Milord. He is appearing for KMDA, Milord. So, Milord, outside the court, Milord, I find Mr. Alok Ghosh, Milord.
How is Mr. Ghosh?
KMD.
Mr. Alok Ghosh is appearing for Milord Kolkata Municipal Corporation.
Okay.
Lordship.
Copy maybe, sir. We have no copy, my lord, about the matter.
Oh, so you appear?
I appeared, but
আচ্ছা তো আপনার ওই 13টা লিঙ্ক তো আচ্ছা
30, Milord.
আচ্ছা having heard the learned advocate appealing for the petitioner and upon perusal of
Extremely grateful, my lord.
7 to 15. No,
Three number.
7 to 15. 7 to 15 is 18.
Grateful.
16, 17.
Well, 16, 17, 18 are different matters.
Oh,
Those are primary teacher matters.
okay,
whereas
okay,
this is,
okay. 7 to
regarding
15. Yes, yes. Mr. Mundar, who is your other side? Oh, come.
all are present. All are present. The last occasion,
এটা শুনেছিলাম হ্যাঁ এটা শুনেছিলাম কি জানো হ্যাঁ বলতে পারবেন Okay, so rest of the matter release for for
First
for this after.
Okay. Yes.
And on the last occasion, your lordship may recollect for your lordship's kind consideration. I gave your lordship a brief overview of the matter. I was placing the SAFTA agreement, that is the South Asian Free Trade Agreements, the relevant clauses. I took your lordship through clauses, Article 3.2, Article 3.2D, Article 3.2C, Article 3.2F, then Article 6. Then Article
that Bangladesh matter.
Bangladesh matter.
Yes.
Article 7.1D, Article 10.1, then Article 10.3, then Article 10.5, then Article 10.6, 10.7, then Article 19 and 21 to 20 clause 6. I've also pointed out that there is a dispute resolution mechanism provided for in the agreement itself. So having regard to this, my lord, what happened thereafter is that kindly take, my lord, for once some relevant facts. But the goods were seized. The goods, namely refined soybean oil, 2 consignments were seized. So, my lord, initially, my lord, the petitioner, before your lordship, approached this honorable court by a writ petition under 226, praying for, my lord, quashing of the seizure order. My lord, this honorable court directed the petitioner to make an application for provisional release. My lord, the petitioner made an application for the provisional release, and consequently, a provisional release order was issued by the department. I mean, the customs department. Now, my lord, the provisional release order was issued subject to fulfillment of 2 conditions. One is, my lord, furnishing of bank guarantee to the extent of 21 crores, and, my lord, furnishing of a purse bond for 43 crores. Bank guarantee is 43 crores, and bond is
Bank guarantee 43
crores, and the release the bond for another 63 crores. So it is 106 crores. This bank guarantee is continuing. The goods have been released provisionally. Then what they did, this is relevant, my lord. Then kindly take, my lord, straight away, come to page 220 of the petition.
Yes.
My lord has got that?
Yes.
Page 220 of the petition. Your lordship will find this is the writing from the CBIC, but the Central Board of Indirect Taxes and Customs. My lord, this is the highest authority so far as, my lord, the regulation and management of the relevant statutes like Customs Act, but previously it was the Central Excise Act, and now it is now the Central GST Act, and to some extent, my lord, the Integrated GST Act, IGST, CGST. But we are concerned with the customs regulation. Similarly, what they did, they wrote a letter or a query, an inquisitorial exercise was undertaken by the Government of India in the Department of Revenue. Kindly, madam, may I just take your lordship through the letter for once, because this is extremely relevant and the responses to this letter would be also be relevant. To the Second Secretary, Trade and Commerce Representative, High Commission of India, plot number so and so, so and so. Verification of country of origin said to be issued in Bangladesh under SAFTA regarding. I'm sorry, madam, your lordship has got that?
Page number?
220. I'm sorry, 220.
220, yes.
Yes, my lord has got that?
You may verify, verification.
Verification of country of origin, which is all the dispute is about.
Oh, এইটা
And I'm sorry, my lord.
ও সে ওটা কোনটা দিয়েছে? এই দেখুন, এইটাই তো। Yes, verification. Now got it.
Yes, my lord. Kindly take the verification for once. It is requested, my lord, may I just take your lordship to the entirety of this particular letter? As your lordship may recollect, my lord, subject to your lordship's kind consideration, it is all about, my lord, the certificate of origin or the country of origin. My lord, there are four classes, namely A, B, C, D. May I just give your lordship a quick recap? My lord, the certificate which was issued by, my lord, the Bangladesh authorities, my lord, there is a specific column, namely column 8, under which, or the box 8, under which, my lord, the inscription was made that it is B category of supply or B category of export from Bangladesh to India. My lord, for B category of export from Bangladesh to India would require 30% of value addition in Bangladesh, domestic value addition in Bangladesh. If it is B category, classically, or, my lord, as per the SAFTA agreement, because that will be my alternative submissions when I will be concluding my submissions. Bangladesh being a least developed nation, my lord, I pointed out to your lordship, your lordship. My lord, this criteria of 30% stands reduced by 10%. So, my lord, it comes down to 20% of domestic value addition in Bangladesh. There are some countries which are covered by this 20%, like, my lord, Bangladesh, Nepal, Afghanistan, and so on and so forth. Only 3. Actually, there are 5. My lord, if it is from Bangladesh, it would be, my lord, minimum requirement is that 20%. My lord, it cannot be gainsaid by anybody from the department that for Bangladesh or imports from Bangladesh, one has to evidence a 30% value addition. But, my lord, the certificate which was issued, my lord, it categorized it as a B class of supply, which means that there had been 30% of value addition. Be that as it may, now I take your lordship to the Government of India's letter. Give me your lordship a quick recap.
Yeah.
Please find attached copies of 2 certificates of origin said to be issued in Bangladesh under South Asian Free Trade Area, SAFTA, for export of refined soybean oil to India. It is requested that a retroactive check, my lord, Article 15 of the agreement provides for a retroactive check, my lord, so that the, my lord, the importing nation could find out whether there had been actually, they can verify the certificate of origin. And that is justified, my lord, because, my lord, there may be some kind of incident which may occur, or there may be some kind of value addition which may not be satisfactory to the Indian government. Now, my lord, now having regard to that, may I proceed? Retroactive check may be conducted, and correctness of the certificate of origin in terms of Rule 15 capital A small a of the Rules of Origin for SAFTA, a response to the attached questionnaire may also be sought from the issuing authorities in this regard. Apart from the above, it is requested that the following documents and information may be sought for the issuing authority. The subject COs, that is certificate of origins, have not been issued as specified in general conditions, that is 1B, 11BI, right? Rules of determination of origin of goods under the agreement of SAFTA. Thus, the reason for not mentioning the value of non-originating material as expressed as a percentage of FOB in box 8 E of COO may be provided. In addition, it may be clarified whether the COO has been issued under Rule 8A or Rule 8B. Relevant documents submitted by the Bangladesh of exporters to the issuing authority of Bangladesh in terms of Article 4, 5, 6, and 8 of the rules of SAFTA. Whether the value of non-originating materials taken to arrive at the FOB value of the export unit conforms to the method of valuation of non-originating materials as defined in Rule 11 of the said rules, as also whether while calculating the eligibility of issuance of certificate of origin, the conditions given in Annexure A were followed. Breakup of FOB value indicating the values of non-originating materials. Names of the non-originating materials may be specified, and different components of DVA, that is domestic value addition. A copy of the communication to the authorities in Bangladesh may kindly be sent to this department for record. But this is a government to government communication. One government, government of India on one hand, and government of Bangladesh on the other hand. And my lord, it was routed to, my lord, this Second Secretary, Trade and Commerce, High Commission of India, posted in Dhaka. Now, my lord, now kindly take the next annexure. This is from the, my lord, the Ministry of Foreign Affairs, Government of the People's Republic of Bangladesh, Dhaka. This is in response to the query made by the Indian government. Again, my lord, a G2G government, G2G, my lord, communication. Because this entire model is based on G2G model. My lord, the business or G2B, my lord, government to business, that is not contemplated in SAFTA so far as the rules are concerned. Now, my lord, kindly come. The Ministry of Foreign Affairs, Government of Republic of Bangladesh, presents to its compliments to the High Commission of India in Dhaka with reference to the latter's note, verbale. This is 17th March, dated so and so 17th March. The honor to intimate that the Bangladesh Export Promotion Council issued the SAFTA certificate in favor of the major refined edible oil exporters of Bangladesh after being satisfied with the rules of origin criteria and duly examining the documents provided by those exporters. The documents provided by those exporters as stipulated under Articles 5, 4, 5, 6, 8 of SAFTA Rules of Origin are also authentic and bears a true picture. The Ministry has further the honor to intimate that the EPB also examined the papers for determination of value addition. The EPB authorities also visited the factories. That is the Export Promotion Bureau of Bangladesh. EPB stands for Export Promotion Bureau of Bangladesh, also visited those factories and rechecked those documents and found that according to the processing cost breakup of the refined soybean oil and palm oil, the local value addition done by those exporters are 30%, and in some cases more than that. The cost breakup provided by those exporters for the certificate of origin are enclosed. The esteemed High Commission is requested to share this information with the authorities in India. The Ministry of Foreign Affairs, Government of the People's Republic of Bangladesh avails this opportunity to renew to the High Commission of India in Dhaka the assurances of its highest consideration. Now, Miller, kindly take the enclosures. The enclosures your lordship will find at page ওটা সার্টিফিকেট গুলো দিয়ে cost sheet. My lord, kindly take, my lord, page 423. My lord, all these materials, man, may I just make it clear? My lord, these materials, that is that, my lord, the government to government communication, the cost sheets or the backup documents were provided along with the show cause notice as, my lord, relied upon documents. RUD. 4. Kindly take page 423 for once. My lord, in this case, my lord, the manufacturer is Deepa Food Products.
Yes.
My lord has got that?
Yes, yes.
The lordship will find in this case they have given the cost breakup. They have given, my lord, they have provided for the details regarding the component of non-originating material, and your lordship will find only take one thing, my lord. Kindly take the last calculation. DVA equal to, my lord has got that at the end.
Yes.
That is, my lord, the FOB value minus the value of non-originating materials divided by FOB value into 100. My lord, that's the percentage being worked out, which, my lord, exceeds 30%. That is 31.73%. Now, the next one is that of, my lord, Meghna edible oils, which your lordship will find at page 425. Now, these are the two consignments.
Yes.
Your lordship will find again the value of the non-originating materials, the value, the extent of domestic value addition, everything has been given, and finally the DVA is computed at the bottom of this, my lord, this cost breakup. Your lordship will find that it exceeds again 30%. It is 31.12%. So, my lord, as of, my lord, may I just pause here for a moment? And, my lord, may I give your lordship the picture as it stands now till this document? That, my lord, two consignments were imported along with certificate of origins issued by the appropriate authority. That is not disputed. These certificate of origin contain provided for category B kind of export, which requires 30% of value addition in the country of origin, being Bangladesh in this case. And, my lord, these certificate, the only, my lord, what should I say? That was a deficiency, was that the extent of value of non-originating material was not provided, the degree or the percentage of DBA was not provided under box 8, being B. They say that you should have stated B at the bottom, either 31.12%, which was not given. So here we stand. The Indian authorities, by following the G2G model as provided for in SAFTA, writes to the Bangladesh authorities, look, we are not satisfied with your certificate of origin, which have been issued. So we are making inquiries. When they make an inquiry, the Bangladesh authorities, the highest authorities of Bangladesh, even your lordship has seen the government letter, again following the G2G model, writes back along with the corroborating evidence to demonstrate that the certificate of origin or certificates of origin for the two consignments, it would be evident therefrom that there had been domestic value addition in excess of 30%, which is a requisite for B category of supply. Now, this is the situation as it stands now. Now, what they do, they again, the Indian authorities, instead of following, your lordship has seen that they are following the route of Article 15 of SAFTA. If they are following the route of Article 15 of SAFTA, then they are also required to follow the route provided in Article 16, read with Article 20 and 21 of SAFTA, which requires, my lord, exchange of correspondences, finally a kind of mediation, and finally a kind of arbitration under 2021. My lord, what they do, they write back again to Bangladesh, again demanding for details. This is at page 439, right? Now, this is at page 439. Again, this is part of RUD. Kindly take my lord 439.
Yes.
Yes, yes, yes. G2G model.
This is by DRI to CBIC.
Okay.
444 Bangladesh to
My lord, kindly take my lord 444. My lord, this is kindly take 444. Kindly take 444. This is pursuant to the receipt of the communication or confirmation. I will not use the term communication. I would use the term confirmation given by the Bangladesh authorities that the certificates of origin are genuine and they are based on facts as assessed. Kindly take my lord the next communication. This is dated 11th of November 2019. Verification visit in respect of country of origin. The undersigned is directed to refer to HCI, High Commission Dhaka, email dated so and so, and CBIC's letter dated so and so, seeking verification of of 8 COs issued to 3 Bangladesh exporters for edible oil under SAFTA. We are concerned with our case. The other exporters are there. We are not concerned with that. We are concerned with 2 consignments. The verification report provided by the issuing authorities of Bangladesh were found to be deficient on many accounts. No document was provided to corroborate that the claims made by the Bangladesh issuing authorities. Further, no clarification was all provided for not mentioning the mandatory value of non-originating material as a percentage of FOB in the light of similar discrepancies having been found in several other certificates of origin. A verification visit of 9 exporters of 582 COs has been made by the CBIC to avoid any further delay in finalization of assessment of customs duty. It may be recalled that the CBIC had requested for facilitating a verification visit to verify the origin norms achieved in import of edible oil from Bangladesh under SAFTA. Vidate's letter dated 28 March 2019, followed by a reminder of 27 June 2019. So far, there has been no response on verification visit request as prescribed under Rule 16 of SAFTA. In absence of any response from Bangladesh issuing authorities for verification visit, which would have allowed consultations as prescribed under 21. So, my lord, the Indian authorities acknowledge the fact that, my lord, the entire dispute resolution mechanism as provided in Article 21 would have to be followed. Before arriving at a conclusion that there is a mistake or error apparent on the face of the, my lord, certificate of origin. Because, my lord, as an importer, I am not in control of the certificates. Certificates are issued from the exporters of Bangladesh in my favor, and I rely on these certificates and claim exemption in terms of the SAFTA agreement. Now, we will kindly take they themselves refer to Article 21 of OCP of SAFTA. CBIC has no other option but to deny the preferential benefit claimed against these 8 COOs should a response be not received within 30 days of this communication. Well, suppose there is no response received. No response is received within 30 days of communication. If they are not satisfied with the clarification given by the Bangladesh authorities, then, my lord, the only course which will be open to them is again participate or initiate a proceedings in terms of Article 20 and 21 of, my lord, SAFTA, because they themselves say that Article 21 would have to be followed. That is evident from this writing itself. Then, my lord, kindly take now the next part, what they do, my lord, the CBIC issues a directive. CBIC issues a directive upon the, my lord, the concerned customs authorities, which your lordship will find at page. Kindly take, my lord, page 447. This is classical, my lord. I don't know what would be, if any adjudication would be of any avail, when the highest authority of India has already made up its mind or has developed a preconditioned mindset so far as the issue in hand. Kindly take, my lord, 447. This is written by, my lord, CBIC to the Additional Director General, Directorate of Revenue Intelligence, Kolkata Zonal Unit. Request for verification of country of origin, investigation into imports of vegetable oils from Bangladesh by Messrs. Imami Agrotech regarding. The undersigned is directed to refer to your communication with reference to so and so dated 31st August 2018 and the board's earlier communication of event number dated 4th June 2019 in the subject captioned above. In this regard, it is informed that CBIC with a letter dated 11th November 2019, copy enclosed, has informed the Bangladesh authorities that the verification report received in respect of 8 COOs involved was found to be deficient on many counts. No documents were provided to corroborate the claims made by Bangladesh issuing authorities, nor any clarification was provided for not mentioning the mandatory value of non-originating material as a percentage of FOB. Accordingly, Bangladesh authorities were requested to respond within 30 days of receipt of the communication, failing which suitable action will be initiated to finalize COOs. Now, Miller, kindly, now I may read out this next paragraph. The subject matter was communicated to the issuing authorities in Bangladesh, letter dated 20th December 2019. However, no response has been received from the issuing authorities till date. Hence, it is requested that the proper officer may finalize the assessment of the subject COs based on available facts. Hence, it is requested that the proper officer may available facts, the action taken in this regard may be communicated to the board for record. My lord, I put the question to myself with all humility. My lord, in your lordships, my lord, this side and that side, both, we know that. My lord, when a superior authority issues a directive to, my lord, a subordinate authority that, look, I am not happy with the certificate of origin. I am dissatisfied with the certificate of origin. I am not also happy with the confirmation letter from Bangladesh authorities. I am also dissatisfied with the confirmation given by Bangladesh authorities. According to me, those are deficient. Then, my lord, when a show cause notice, when he directs the proper officer or the, my lord, the adjudicating authority to issue a show cause notice, then, my lord, the adjudication proceedings and the result of the adjudication proceedings would be fait accompli. It is like classical case of authorities, subordinate authorities being bound to act as per the diktat of these superior authorities. That you do this and submit a report. I want this to be done. I want them to teach a lesson. So this is what is happening. But taking your lordship back once again. I take your lordship, these two letters, I at the cost of repetition, I beseech your lordship to kindly come back to 444 once again. Because these two letters would hold the key to this entire issue.
447.
444. I read 444 and 447. I beseech your lordship, my lord.
Yes.
I crave this indulgence from your lordship. I take your lordship to last sentence of paragraph 3. In absence of any response from Bangladesh issuing authorities for verification visit which would have been allowed consultation as prescribed under Article 21 of the OCP of SAFTA. CBIC has now no other option but to deny the preferential benefit claimed against the 8 COs. Well, we are concerned with 2 COs. Should a response be not received within 30 days of this communication, though it is, my lord, a communication from government to government, that's the G2G model, but indication is made clear. CBIC has made up its mind. CBIC has predetermined the issue, prejudged the issue, that since if there is no response, I am going to deny. Then, my lord, the entire process of the show cause proceedings or the adjudication proceedings, my lord, the fate is known to one and all. And this is what is reflected at page 447. Kindly take, my lord, 447 once, because I will be traveling with this particular communication. Your lordship will find the first paragraph of 447. Kindly take first paragraph of 447. The undersigned is directed to refer to your communication with reference to so and so dated 31st August 2018 and the board's earlier communication number dated 4th of June 2019, copy enclosed on the subject above. In this regard, it is informed CBIC by with a letter dated 11th November, copy enclosed, had informed. This is referring to page 444. So, this copy is enclosed. So they enclose the copy where the CBIC has made up its mind that no preferential benefit could be given in favor of the importer and directs the subordinate authority, namely the proper officer, to finalize the assessment and issue show cause notice. And this is what has been happening, my lord. This is the sum and substance of this case, that, my lord, what kind of treatment would an importer would get when the highest authority of the land, so far as, my lord, these indirect taxes are concerned, has already made up its mind and directed the subordinate authority to finalize the assessment. Now, my lord, taking your lordship back, now, my lord, what they do, my lord, as obedient as the proper officer is, proper officer issues a show cause notice. Kindly take the show cause notice for once, which your lordship will find at 223. Yes, my lord.
Yes.
My lord has got that? I will only read the relevant parts of the show cause notice. Kindly take paragraph 3.2, just for reference. I am not going to read that. My lord, this covers, my lord, the 2 consignments, 3.2 at 225. 225.
Yes.
My lord has got that?
Yes.
Scrutiny of the aforesaid SAFTA certificates of origin issued by the competent authority of Bangladesh, that is Export Promotion Bureau of Bangladesh, hereinafter referred as EPB Bangladesh, reveals that the said SAFTA COOs bearing number EPB 18 so and so dated 23rd July 2018 were issued by mentioning the origin criterion as B. But I told you, lordship, it is all about A, B, C, D. B is 30% and D is, my lord, for these developed nations, which comes to 20%. So, my lord, even if assuming, though not admitting it is not 30%, I will demonstrate from the affidavit of the, my lord, these revenue authorities which have been filed pursuant to directions given by your lordships, that, my lord, there has been a value addition of admittedly 21%. Admittedly. For Bangladesh, 20% is enough. Now, my lord, coming back to the show cause notice, because I stick to my stand that once the Bangladesh authorities have confirmed that there has been a domestic value addition of 30%, it is not gainsaid by any Indian authority to challenge that particular, my lord, this determination or, my lord, this assertion made by the Bangladesh authorities on by responding to the queries made by the Indian government, unless and until, my lord, a full-fledged dispute resolution is undertaken in terms of the SAFTA. Now, my lord, may I just read 3.3? This would be relevant. Scrutiny of the aforesaid SAFTA certificates of origin issued by the competent authority of Bangladesh, that is Export Promotion Bureau of Bangladesh, reveals that SAFTA COs bearing number so and so were issued by mentioning origin criterion as B in column 8 of the respective certificates. However, the vital information about value of non-originating material which is to be expressed as a percentage of the FOB followed by the letter B is not given in any of the certificates. Mentioning the value of non-originating material is mandatory to arrive at the domestic value addition at the end of the exporting contracting state, in which in case of imports of refined soybean oil should not be less than 30% as per Annexure A to Rule 8 of SAFTA rules as discussed in the succeeding para. If it is found that the DBA is less than 30%, the imported goods will not merit benefit of duty exemption under the agreement of SAFTA. This would result in violation of condition IIB of rules of determination of origin of goods under the agreement of South Asian Free Trade Area, that is SAFTA. Now, will kindly take over. But this was the only reason for which, Malad, the provisional release order was issued, and we had to furnish a bank guarantee of 43 crores and, my lord, and also a bond of 60 crores. 64 crores. 64 crores. Now, my lord, kindly take your, may I take your lordship to other parts of this particular show cause notice. Kindly take paragraph 7. Page 231. Lordship still uses that old school pencil. While writing, Lordship still uses that old school pencil.
Pencil. 7. Yes, 7.
Kindly, may I take your Lordship to paragraph 7. As discussed supra, SAFTA COOs, that is certificate of were issued under category B without mentioning the value of non-originating material which is to be expressed as a percentage of FOB mentioned therewith. This has resulted in the violation of condition IIB of the rules of determination of origin under the agreement of SAFTA. In terms of Appendix 1 of rules of determination of SAFTA, which stipulates the format in which the certificates of origin or South Asian Free Trade Area, if the origin criterion is given in B, then the products so exported should meet the origin criteria in Rule 8, and the letter B should be followed by the value of the non-originating material expressed as a percentage of FOB value of the products. The extracts of the relevant portions of rules of determination of origin under the agreement of SAFTA is reproduced as under. Well, I am not taking troubling your lordship with this again. Kindly take, my lord, now paragraph 7.4.
Yes.
The whole allegation is that you have written B. Where is the percentage of the non-originating material below B under box 8? Thus, it is clear. Kindly take the last 6 lines.
Thus, it is clear.
Thus, it is clear. My lord has got that?
Yes.
Thus, it is clear that if a SAFTA COO is issued without mentioning the value of non-originating material expressed as a percentage of the FOB value of products, then there is a typo, I think. Then such SAFTAs COs are to be taken as being issued without following the provisions of SAFTA rules of origin, and products covered under such SAFTA COOs will not attract preferential treatment. Kindly mark these words: will not attract preferential treatment. The communication dated 11th of November 2029, correct? Issued by Indian government to my lord Bangladesh government. At paragraph 3, it is stated that if you don't give us the opportunity to inspect the site or give further clarifications, we will deny the preferential treatment or preferential benefit. This 11th November 2029 communication is enclosed along with the directive to the proper officer that you finalize the assessment, which shows that the whole purpose of the assessment is that at the very inception of the entire proceedings is to deny the preferential benefit which is otherwise allowable to an importer in India by reason of the provisions of SAFTA. So, my lord, the links in the chain are well established. The first link in the chain is the communication from Indian government to Bangladesh government that if you don't give further clarification, I am going to deny preferential benefit. Then a directive issued to the proper officer that you finalize the assessment. As an enclosure to that directive, there is the 11th November 2019 communication is there as annexed, and that enclosure clearly says that we will not give preferential treatment. And now, from perusal of paragraph 7.4, yes, that will come. And your lordship will find from the last 6 lines of paragraph 7.4, the whole objective is to deny. This entire proceedings, it is just like an useless formality, idle ritual. Therefore, kindly take paragraph 7.5. In the instant case, submission of 2 SAFTA COs, so and so, apparently issued by Export Promotion Bureau of Bangladesh is in violation of. So now, my lord, they are making allegations against Export Promotion Bureau of Bangladesh, which is again a G2G model issue, not a G2B model issue. It's a G2G model issue. Violation of clause condition number 11 YIB of rules of determination of origin under the agreement of the SAFTA and fails to satisfy the true origin of the imported refined soybean oil for the purpose of extending preferential treatment under SAFTA and the exemption of duty under notification 99 of 2011 dated 9/11/2011. So it is clear, my lord. Now the focus in the show cause notice shifts from G2B to G2G when the other government cannot participate in this proceeding, naturally cannot participate. They could have participated in the proceedings had there been a kind of, my lord, had they followed the dispute resolution mechanism provided for in SAFTA. Now, my lord, kindly come. Now it gets interesting. Kindly come from paragraph 9.1, page 236. But I will not read, my lord, I will not read because I don't want to waste your lordship's precious time. This time is very important now. Yes. Report. Your lordship will find they refer to the communications, the reply from Bangladesh authorities. Sorry, 236. So they refer to the initial communication from India to Bangladesh. They refer to the confirmation given by Bangladesh. Then kindly come to paragraph 9.3. Because these I have read, my lord, I need not repeat. The above assertions by the Bangladesh authorities have been examined along with the cost sheets given on the reverse of the SAFTA certificates. During the scrutiny of the explanation vis-a-vis the cost sheet, several contradictions have been noticed in the assertions made by Bangladeshi authorities. Which are as under 9.3.1, Article 8 of SAFTA Rules of Origin specifies that certificate of origin issued by the issuing authority should indicate the applicable rules of origin and the value of non-originating material expressed as percentage of the FOB value of the goods. However, in the SAFTA certificates bearing number so and so issued by Bangladesh EPB, box 8 is found to have letter B. Again, Malady, it is repetitive. Without any value of non-originating material expressed as a percentage of FOB. This is just repetition of paragraph 7.1 of the show cause notice. As regards Articles 4, 5, and 6 of SAFTA rules of origin, no such verification reports have been supplied to back their claims. Whose claims? Bangladesh authorities, not my claim. As regards processing cost breakup of the refined soybean oil, the cost sheet provided by Bangladesh EPB, that is Export Promotion Bureau, are found to have following discrepancies and anomalies. In the case of SAFTA bearing so and so Meghna edible oils, now, my lord, they point out the alleged anomalies in the certificates issued by the Bangladesh authorities and the cost sheets provided by the Bangladesh authorities, and, my lord, which has been confirmed by the Bangladesh authorities. They undertook site visit, as would be evident from the letter issued by the Bangladesh authorities. In spite of all this, my lord, 9.3, this paragraph is dedicated entirely to, my lord, the discrepancies which have not been rectified by Bangladesh authorities on the request made by the Indian government as alleged, not at all. 9.3 is in entirety, is, my lord, this is the case. So, my lord, they deal with that, and now, my lord, kindly take 9.3.4. In view of the above, paras 3, 4, and 5, it appears that Bangladesh had sourced almost the entire quantity of soybean oils by importing from other countries. Further, as he discussed above, as per the export policy of Bangladesh, export of soybean oil is absolutely prohibited. Therefore, the claim of producing soybean oil from indigenous seeds by the said two suppliers of Bangladesh and export the same to Imami Agrotech appears to be incorrect, and therefore credibilities of COs read with other relevant documents is no longer there. Again, my lord, again it is an allegation against the Bangladesh authorities. We'll come to that. My lord, kindly along with this read 239 of page 239, paragraph 3. My lord, this assertion, further, the claim of Bangladesh authorities in full contradiction of export policy of Bangladesh 2015-2018, as according to para 8.1 of the policy, export of soybean oil and palm oil is absolutely prohibited for export from Bangladesh. Even conditional export of soybean oil is not allowed by the export policy. Investigation reveals that government of Bangladesh allowed some parties, including Deepa and Meghna, to import duty-free import of soybean and palm oil for the purpose of export to India, Nepal, and Bhutan with some value addition. And for that purpose, Bangladesh government issued some quantitative license to these parties. Look at this, this clear allegation which could only be examined or adjudicated by following the procedure laid down in SAFTA. These allegations clearly show, and admittedly, they say that there has been value addition. There has been value addition. They don't say about the degree or the percentage of value addition. They say there has been some value addition. So if this be the case, then it is a dispute between India and Bangladesh. If it is a dispute between two governments in a G2G model as envisaged in SAFTA, the importer in India cannot subject it to show cause proceedings unless and until that dispute is resolved this way or that way. I am not here to decide, make that submission, which way it will go. This way or that way by the appropriate authority provided for in SAFTA. So, my lord, kindly take, my lord, 9.3.4 I read. Then, my lord, kindly take paragraph 10. So this is very interesting. Kindly
Yes.
take paragraph 10 at page 242.
242, yes.
But this is extremely interesting, my lord.
Yes.
Well, I will not trouble your lordship with this entirety of this, my lord, this paragraph. It's a longish paragraph. II, kindly take II. But kindly take, my lord, from the sentence which starts with the expression the DVA domestic value addition formula. But has got that. The DVA domestic value addition formula. This is 5, 6, 12 lines from the top of paragraph II. The DVA domestic addition formula.
Yes.
My lord has got that.
Yes.
Is given, man. I'm just skipping over because time will
Yes,
be wasted.
yes.
Time will be wasted. The DVA formula is given in the SAFTA rules as DVA equal to FOB value of export product minus CNF value of non-originating materials into 100 divided by FOB value of the export product. By applying this formula, if the minimum CNF value of USD 716, this is their own assertion, is taken for the non-originating materials, that is crude degummed soybean oil, the domestic value addition would be 909 minus 716 divided by 909 into 100. Here USD 909 is the FOB value of the imported goods under investigation and 716 is the value of non-originating material, a maximum of 21.23%. So, even if we take the best case of revenue forward, the best case of revenue forward as portrayed in the show cause notice, there has been a value addition in excess of 20%. And for a least developed nation like Bangladesh, it is a matter of fact that any value addition in excess of 20% would qualify for exemption under SAFTA. This is their case, 21, which is much less than the minimum value addition of 30% required for to be eligible for benefit under SAFTA for this product. Absolutely wrong. But first of all, my case is that it is above 30%. Second of all, if I take their case forward, if I adopt their case, even if assuming though not admitting they are correct, then for Bangladesh, imports from Bangladesh being a least developed nation, only value addition to the extent of 20% would qualify for exemption. That's all, nothing more. So, this is their case. Now, kindly take, Roman 6 at page 243.
Yes.
Considering the above, if rate of so and so is charged by Bangladeshi suppliers for supply of refined soybean oil, in this case, is taken for consideration and tariff value of non-originating material, crude soybean oil is taken at so and so, then for the purpose of calculation of DVA, DVA would be a maximum of 20.46%. They give a figure, their own computation, not my computation, which demonstrates beyond doubt that there has been a value addition in Bangladesh to the extent of more than 20%. As against the prescribed minimum DVA of 30% in respect of refined soybean oil. Further, it appears from investigation the Bangladeshi suppliers and Messrs. Imami Agrotech were very much aware that domestic value addition in case of processing of refined soybean oil cannot touch the minimum levels required for SAFTA. Sorry, madam, I beseech your lordship, kindly record that I am sorry that they have not understood SAFTA at all. Being the administrators of SAFTA, they have failed to understood the implication of SAFTA. And thus, with a malafide intent, now they come to malafide intent. Whose malafide intent? I put the question to myself. They are making allegations against the Bangladesh government, virulent attack on the certificates issued by Bangladesh government, confirmation given by Bangladesh government, and they say that I have proceeded with malafide intent. But the value of non-originating material in the is not given in the SAFTA certificate in box B. Then, my lord, it comes to the legal provisions, which I am not bothering your lordship, because, my lord, I am on the question of jurisdiction and the jurisdictional fact. Your lordship, my lord, your lordship has dealt with in so many matters, this side or that side. My lord, so far as show cause notice is concerned, my lord, all we have to establish is that there has been a jurisdictional error, or the jurisdictional fact did not exist so as to warrant issuance of show cause notice. My lord, my first case before lordship is that if we take Article 2021 the page table, my lord, if your lordship kindly take, I take your lordship back to where I started. Kindly take page 46. 46 টাই দেখ।
Yes.
Kindly take page 46.
Article 20.
Dispute settlement mechanism. Any dispute that may arise among the contracting states. Well, the SCN clearly demonstrate there is a dispute between India and Bangladesh. Paragraph 9.3 speaks voluminously of such dispute. Any dispute that may arise among the contracting states regarding the interpretation and application of the provisions of this agreement and any instrument adopted within the framework concerning the rights and obligations of the contracting states will be amicably settled among the parties concerned through a process initiated by a request for bilateral consultation. Any contracting state may request consultations in accordance with paragraph 1 of this article with other contracting state in writing, stating the reasons for the request, including identification of the measures at issue. All such requests should be notified to the committee of experts through the SAC secretariat with the indication of the legal basis of the where there is no complaint lodged with the committee of experts. They just hopscotch to the process of issuing show cause. It's like bypassing this entire mechanism which is provided for in SAFTA. If the does not respond within 15 days from the date of receipt of the request, or does not enter into consultations within a period of no more than 30 days, or a period otherwise mutually agreed, after the date of receipt of the request, then the contracting state that requested the holding of consultations may proceed to request the committee. So, if we take the writing of 11th November 2019, they say that if you do not respond within 30 days, I am going to take measures for denying the preferential benefit. Your lordship recollects that. If we read, my lord, this clause 4, the recourse which they could have taken under these circumstances, since there is no response from the contracting state, namely Bangladesh, what they could have done? They could have taken recourse to 20 clause 4, Article 20 clause 4. Settle the dispute. Neither any complaint was lodged with the COE, that is the committee of experts.
Committee of experts.
Nor, my lord, after expiry of 30 days. I say that, my lord, I take their best case forward. That yes, Bangladesh authorities were not cooperative in that sense. Then what is the recourse open? The recourse which is open to the Indian authorities is to follow the mechanism provided for in clause 4 of Article 20 of SAFTA, and not otherwise. Then, my lord, kindly take, may I proceed further? Settle the dispute in accordance with working procedures to be drawn up by the committee. Consultation shall be confidential and without prejudice to the rights of any contracting state in any further proceedings. My lord, these stages are like this, my lord. India writes to Bangladesh that please provide me the details regarding the COs. Bangladesh writes back that these are the details. I am also giving you the court sheet and I'm also giving you the certificate of origin. I'm confirming that the certificate of origin is correct. Indian authorities write back to Bangladesh that whatever you have given, your report is deficient. I am using their language only. So you write back you respond within 30 days. Otherwise, what could have been other step taken otherwise is a step which which is contemplated in clause 4 of Article 20 and not anything else. I pause here today, my lord. May I continue on some other day, but subject to your lordship's clause. Time is a constraint, but my lord, your lordship, but this is an interesting matter, my lord.
Yes, yes.
At least, my lord, your lordship will not get, my lord, this is new for me.
Yes.
It's
Yes.
absolutely new.
No, new for the court also.
No, it's new for me, my lord.
Yes.
My lord, it's a
Your main contention is that they should have followed the procedure
Yes,
prescribed under SAPTA. SAPTA.
Well,
They should
next
have
day-
take up,
well, next day I
take up
think
the
that-
issue with Bangladesh government and follow the procedure. If they are aggrieved, they could have approached the expert committees as other.
Right. May I come back any day next week, subject to your lordship's pleasure?
Next week, দেখুন তো। Next week.
Pardon, my lord, I have the list, item number 5. Just by whisker I have missed, my lord. This was dismissed for default. Just for not.
ডিসমিস করতে হবে না, 5টা বলে দেবেন। আচ্ছা, নেক্সট উইক কবে? একটা 12টা থেকে দিয়ে দিন।
Item number 5. 126.
Here for the petitioner.
In last occasion when the matter was taken up, this is a list I would like to bring to Milord's notice. Down list. আরেকটা copy আছে? But there are more or less 37 matters, Milord. There might be a few more also which we have not been able to ascertain, Milord. Maximum of these matters have already been mentioned before my Lord Justice Shubhendu Samanto's bench, Milord, which my Lord Justice will be taking up, Milord. Milord, these matters, Milord, to my understanding, Milord, should be taken up together, Milord, and it will be easier for the state also to respond. Mr.
It is pending before the Justice, Honorable Justice Vikas Pattanay.
No, Milord, this is, Milord, as per the, Milord, this is as per the list which is available in the datas of the High Court. But it is already been mentioned. Maximum of the matters have already been mentioned before Justice Samanto, Milord, because Justice Samanto is right now having the Group 1 determination. And Milord, all these matters, Milord, there are in maximum of the matters the affidavits have been
Group
directed.
1 land matter. Group 1 land matter. Mr. Sen, Justice Sen.
No, this is Shubhendu Samanto. It has been mentioned before, Milord. Mentioning is pursuant to the desires of the petitioners, not before of us.
Group 1 matter, Justice Sen.
Milord, this list have been old.
Oh.
And Milord, what we have done, Milord, we have already sought an intervention of the Honorable Chief Justice, Milord. Day after tomorrow, Milord, the OSD has given us time to look into all these 37 matters, that whether how this can be adjudicated by a single bench. Because
It is 38 matter
38.
before me.
No, before my lords, only one matter. Right. কত নম্বর serial number কত? 11.
So what can be done, Mr.
This matter, well, your lordship kindly takes up this matter only.
State want to get the matter heard out and disposed of by another court, another bench.
If everything comes before my lord, it will be before my
How
lord.
no?
Lord, if everything
No, how?
Lord, it will be before my lord. Lord, we have no difficulty.
After taking note of such stand of the state, how can court?
My lord will kindly not take a Thomas. My lord, if everything is before my lord, everything is before my lord. We have no difficulty.
Let this matter be taken up by your lordship. Every matter has
Let
its-
the matter placed. It would be better so that the conflict of
those
decision can
matters
be
are
avoided.
Those matters are not in the list.
দাদা কি সব মামলায় আছে?
This is in the
I
list.
say no.
Well, let those matters be listed. Thereafter, your lordship kindly release. Otherwise, this will be, well, sine die. This will be, well, adjourned.
We are not asking for it.
No, not in that. Actually, it would be better. I was just joking. It would be better so that similar matter can be heard by same
But
bench.
any bench, even this bench.
Same bench, so
Till
that
such time, your lordship kindly adjourn. But if those matters are listed, I will be praying for release of this matter. These are, my lord, this is happening for last 5 years.
37 matters is pending before another court and one matter before me.
In no court. It is not pending.
consider.
It is not
You
pending in
consider.
any court. It is not pending in any court.
Okay.
Let it be listed first. Thereafter, your lordship kindly release my matter. Otherwise, this is shown for last 5 years. 37 matters, 37 matters. I am suffering. Let it be adjourned for 7 days, 10 days.
My lord,
Then,
your friend is
in
also
that circumstance, I am not releasing, let the matter go out of list. As and when it would be listed, you also you will be able to mention.
37 matters may not be listed at in
I mean, as prayed for, as jointly prayed.
Or your lordship, my lord, could have taken all these matters. Your lordship have the determination.
All matters can be taken up by
Your lordships have the.
I have no problem.
Why they are mentioning in.
They
current
want
slide-
to,
No, I have not mentioned. The petitioners have mentioned.
oh, state want to get the matter disposed of by another bench. Why are
Millard will
creating one in
kindly appreciate. Millard, state did not mention it before any bench. The petitioners in those matters have mentioned in that bench. We have not mentioned.
I am for the petitioner in many matters. I have not mentioned.
Others have mentioned. It is
From
not,
Millard
it is not
state.
us, we have mentioned. Millard, why will the state go and mention for disposal of a writ petition?
Okay, however, even Mr. Nag,
Millard.
Mr. Nag, settle the dispute.
Millard. We
so
will
that,
take it up with the OSD.
so that the matter can be disposed of, whatever may be.
Millard.
Problem is that whether you will go for direct purchase or you will pay compensation according to the applicable act.
Or it will be heard. Or it will be heard on merits, Millard, whatever.
So you resolve the issue
Millard.
without keeping it pending.
Millard.
Okay, what can be done?
Let this matter never be taken up.
Oblige, Millard. তুমি মেনশন করো না দাদা, তুমি এটা চিঠি দিয়ে দাও।
পাঁচটা উঠলে তুমি বলবে 37টা ম্যাটার।
তুমি
Everywhere you will take the same step.
Let the petitioners approach, my lord, the Chief Justice, my lord, so that everything can be taken up in one matters. The exercise we are trying to do, so that there is no dispute in this matter, the petitioners do not bother. They only want, perhaps they have chosen one of their best cases, and they want to do that and show a crocodile and get orders in the rest. We don't want that.
Let all the matters.
It is about
be
this.
for your lordship.
Yes.
I will meet you tomorrow.
Yes.
Whether it can be equally applicable to the state also.
Millard, we are supposed to give
They
the money
will
from
get the
public
money,
exchequer.
state will is to pay.
Millard, it is a case. Millard will kindly appreciate. It is a case of the petitioners who had been sleeping on their rights for years, and now they want to have the benefit of the state exchequer.
My land has been taken away.
Millard, there are
taken
pumps
away.
which have.
Mr. Nag, in this matter, I can recall, in this matter, it is the stand of the petitioner that even the petitioner is agreed to accept your direct purchase proposal.
Millard, in all matters,
You
they
have-
have not agreed. Millard,
Particularly in this matter.
This matter, let it be decided.
Millard, the reason is as it has to be like a policy for the entire state, or else.
Policy is that case-to-case basis.
Yeah,
You formulate policy later on.
Millard, I would not
In
like.
this matter, you mooted a proposal that you will purchase directly from the landowner.
I agree to that.
Even he expressed agreement to that proposal. Yes, even he is agreed to accept the valuation prepared by your district sub-registrar.
Yes, absolutely.
It is your valuation. Time to time you revise it. Okay, it is your valuation. Valuation made by the state. He is not saying that I will make valuation of the land. He is ready to accept the valuation made by the state. Yes, I agree. Give me that value. But you will not. You have acquired the land. You have utilized the land. So you will not pay the compensation according to the act. I don't know whether 13 Act will be applicable or not. 13 Act or direct purchase policy. You adopt your state. You can
After
adopt this
all
policy.
this happened,
this
we
matter
filed the affidavit in opposition.
If it is in accordance with law.
Millard, after all this happened, Millard, we went and filed an affidavit in opposition because we came across that after one matter, it went up to become 37 matters. And we apprehend that it might be more. Because, Millard, there have been situations, I would be very candid, Millard, that there are matters which are very old, which we are getting difficulty to recover the scenarios.
Difficulty you have to overcome.
We will.
You have acquired the land way back in 2015. For 10 years, you are enjoying the land, utilizing the land, without paying a single farthing to the owner of the land. Whether his constitutional right is being violated or not. At the hands of the state.
In one case,
at the hands of the state, you kindly say.
Millard, subject to correction, Millard, he has accepted our case.
Now he
given
his right under 300
he has waived his right for affidavit in reply. He has accepted our case.
He will not give anything. You have taken his land, you pay the land. Now you have suddenly you have stated, no, I shall introduce a direct trade policy.
No, this is
But you have no definite stand. When the person who has lost his land, he stated, yes, I am agree. I am agree, yes, to accept even the valuation made by your district sub-register. You are not in. Now you are showing 37 matters such and such, 47 matters such and such. In this way, 10 years has gone.
An aerial view has to be taken because it is about the state exchequer.
In on matter, direct, my lord, the acquisition has been directed under Act 13. That has been acted upon in this case. I will place that order. Your lordship kindly take up this matter or fix any day. They are taking dual stand.
Article 30, Article 31, Article 300, you cannot take the land of any person without following the procedure of law.
I don't disagree, my lord.
Maybe you have the power of eminent domain.
My lord, that is not the power which is ultimate.
Eminent domain power you have got.
That is
You can acquire the land, but you have to follow the procedure.
Absolutely.
Follow the land.
Absolutely.
And it is his constitutional right. Forget about that. It is not fundamental right, but it is a constitutional right. Right to property is a constitutional right, 300 days. Okay, so you have pitched that, you have taken that land, but 10 years has elapsed, you have not paid a single farthing to the landowner. It is the situation. Ground reality. Now you are saying that I shall introduce direct price policy such and such. I don't know what will be the is legality, which act will permit so. I don't know. Later on it would be.
Your lordship have the determination of 2015. Let all the matters be listed before your lordship.
Yes.
Everyone is agreed. Everyone is agreed. All the matters be listed before your lordship.
Islam,
Let state is
unless the petitioner mentioned this matter,
I am petitioner. Most of the matter I am petitioner. I am for the petitioner. I am mentioning they are agreed. Let all those matters.
This could have been done long back.
You mentioned before the Samanto.
This could have been done long
State
back.
will find state will find itself compatible before that bench. State will find itself compatible before that bench has go.
But state did not mention there. State is not taking any responsibility of making the
Okay, later.
Tomorrow I will be coming for mentioning all the matters. Your lordship.
Try your luck before that.
No, before your lordship, I shall try. Let the state's stand be tested here.
I have no problem with it.
He is
Let
no
him
problem.
mention.
Let it
Let
be, my
him
lord.
mention.
List is there. 37 matters list is there, your lordship. All the matters we tag together and later.
In all the matter, you are the petitioner. There are some other petitioner.
3 matters.
Now you will convene a meeting. Come all the matters,
matters.
all the petitioners with me.
23 matters I am for the petitioner. Rest, my lord, oxygen.
Oh God.
Ravi Shankar Chatterjee is in other matters.
Okay, do whatever you do today. Yes. Oh.
For the petition.
Yes.
This pertains to the challenge to the order of the disciplinary.
Oh. Disciplinary proceeding.
Yes. So order of the disciplinary authority dismissing me from the service.
Remove.
Yes, without anything else.
Remove, not dismiss.
Yes, I tell you, Lordship.
Where is the order? Dismissal or removal?
That your Lordship will find, my lord, at the volume 2, the writ petition, page number 420.
420.
This dismissal order is of 28 page. So, my lord,
420.
Yes, it starts 4
Operative part.
449.
Yes, tell the fact.
My lord, at first, my lord, I just I'll just take your lordship, my lord, only to lordship will not kindly, my lord, see the, my lord, size of the brief, my lord. Here the point is very simple. My lord, initially, my lord, there has been a charge against me, my lord. Before going to the charge, my lord, I'll just, because it is with respect to, my lord, the recruitment process of the Public Service Commission examination. So, my lord, it was with respect to, my lord, Group A, B, C employees for the recruitment of those employees. So, my lord, lordship knows, my lord, the setup of the examination is like there will be, my lord, 6 papers, 6 compulsory papers, and, my lord, there will be 2 optional papers. So, the persons, my lord, who sit for this examination, who, my lord, gives the examination with respect to all 6 compulsory, as also 2 optional, will be, my lord, decided, his candidature will be decided against A and B category of the employment. And the persons who sit for the examination and only answers or competes in the compulsory examination 6 papers and does not go into this optional 2 papers, then his candidate
Yes, Mr. Ross.
Then, my lord, his could I just, my lord, come back after?
No. You continue.
So, my lord, the persons who only, my lord, sit for the examination of the compulsory papers and do not go into the optional papers, then his candidature will be considered against C and D, not A and D.
Consider C and
D. Group C employees, Group D employees of the
okay. Okay.
Here,
Yes.
my lord, what happened? That is the setup of the examination. That is the crux of the entire matter will be, and nothing else. Now, my lord, what happens? Here, my lord, I am, my lord, one, my lord, one upper division clerk, UDC, of the Public Service Examination Commission, Public Service Commission's upper division clerk, I was. So, my lord, what happened in this particular year, my lord, my daughter, my sister, who is a married sister. So she sat for this examination of Public Service Commission, and she specifically sat for the examination for these compulsory papers, not for the 2 other optional papers. So her name is So her name is Somdatta Ganeriwala. So she, my lord, compete for this compulsory papers only and did not go for these optional papers. So that means she clearly wanted to be, my lord, considered against the C and D post, not A and B post. So, my lord, the charge was that I did not want first charge. If I just take your lordship to the article of the charge first, that your lordship will find at page number volume 1, at page number 203. The article of charge your lordship will find 04.
Yes.
So the article of charge, may I not place? It appears that Kaushik Bhattacharya, petitioner before your lordship, upper division assistant, presently under suspension, was attached to confidential section of the office of the PSC. At the time of preparation of the final merit list of eligible candidates for the West Bengal Civil Service Executive etc. examination 2017, Group C services and posts, it came to the notice of the office that one candidate, namely Somdatta Ganeriwala, daughter of Dijodash Bhattacharya, featured merit list. It was also learned that Srimati Ganeriwala is the sister of Kaushik Bhattacharya. It also appears that Sri Kaushik Bhattacharya is a candidate for WBCS Executive etc. examination 2017. Shri Bhattacharya, in his reply to show cause, intimated that he had informed the Deputy Secretary of the fact, but he did not produce any document in support of his claim that he informed the Deputy Secretary about the candidature of his sister in the said examination. That was the first charge. Then my lord comes down to the second charge. It appears that Kaushik Bhattacharya, presently under suspension of Office of the Public Service Commission and to process the data received through email from HON'BLE and other agencies for tabulation and preparation of merit list in different stages of examination. He was also entrusted with computer related works for the said purpose. As per prevailing system, Shri Bhattacharya had free access to the email of the Deputy Secretary where the result of different examinations was received by the HON'BLE and other agency. Even it is reported that the said email of Deputy Secretary was opened by him with his mobile number as registered mobile number. It is also evident that he used the said email for his personal purpose. It is not yet the charge. Then the next paragraph also does not contemplate the charge. I'll place. It is also reported that Sri Kaushik Bhattacharya, Upper Division Assistant, presently under suspension of such and such, and two optional, processed the marks of 6 compulsory and 2 optional papers as was received from WB HON'BLE, etc. examination. Sri Bhattacharya generated a working list in hard copy from the computerized data with candidates to be called to personality test for Group C services and post and provided the same to the confidential section for necessary action. He had also prepared a detailed program of personality test of the said examination. Accordingly, the candidates were called to interview. Interview marks of the candidates were checked by the said selection and handed over to Sri Bhattacharya for tabulation. Sri Bhattacharya prepared a tabulation sheet comprising total marks of 6 compulsory papers and interview marks with aggregate in respect of 1, 2, 4, 5 candidates. He also prepared a general standard merit list and a deluxe standard list arranged according to the rank on the basis of the tabulation sheet and handed over the same to the dealing assistant of the confidential section. Both the lists were put up by the confidential section for approval. Still, my lord, it is not a charge. It is, they say this is my duty. Then comes the charge. It has come to the notice of the authority that marks of few candidates may have been fabricated. Accordingly, marks of the candidates in the merit list as prepared by Sri Bhattacharya, Upper Division Assistant, present under suspension, were verified with fresh tabulation sheet obtained from HON'BLE. On verification, it was detected that marks of the following 5 candidates have been fabricated. My lord, name of 5 persons are there. Serial number 3, my lord sees. Somdatta, my sister. It also appears that the candidate Somdatta is the sister of Bhattacharya, and Kaushik Bhattacharya provided a tabulation sheet of all candidates who appeared in the main examination of WBCS executive examination to the personal assistant to the honorary chairman. And it is evident that the marks of above 5 candidates have been fabricated. In this state, it is evident that Sri Kaushik Bhattacharya, presently under suspension, has manipulated and fabricated the marks of the above 5 candidates with ulterior motive to make them eligible for interview selected in the final merit list. Such act of fabrication is clear in misconduct, fraud, as well as lack of integrity, impartiality, and devotion of the duty of such and such. Sri Kaushik Bhattacharya under suspension is stated in his explanation that now, my lord, last paragraph, page number 206. It stated in his explanation that he did not act as a dealing assistant in the instant matter and he did not sign the merit list of Group C services. And did all computer related works and processing the data received, viewable and generated tabulation sheet, merit list of the candidate of interview. Hence the charge. So, my lord, basically there are two charges. One of them is that I did not intimate that my sister is competing in the examination. Two, I caused. They do not say that I manipulated. They say that I caused manipulation of 5% tabulation sheet, because that means, my lord, we get X mark from the viewable, but while preparing the tabulation sheet, I make it X plus 2 or Y mark in the tabulation sheet, so that these 5 individuals get the chance in the interview. So these are the two charges. Now, my lord, I just take your lordship with respect to the first charge, that I did not inform this. The charge sheet itself, the article of charge itself says that I specifically stated this thing to the authority that my sister is sitting, but I could not produce any document to that effect, hence the charge. That is written in the article of charge itself. Once again, my lord, kindly see page number 204. Article of charge, first paragraph, last but 4 line. In the middle, it starts from Shri Bhattacharya in his reply. Has your lordship got this one? Shri Bhattacharya in his reply to show cause intimated that he had informed the deputy secretary of the fact, but he did not produce any document in support of his claim that he informed the deputy secretary about the candidature of his sister in the said examination. So, my lord, in my defense, my lord, I have specifically stated every other facts. I will not take your lordship the entire. It starts from page number 210. So, my lord, I could not produce any document, because I tell your lordship that when I intimated this thing, as per I have stated that thing in my written representation, reply against the show cause, by saying that it is the official process whenever any family members of our I'm sorry, man. Any family members of our
staff,
yes, it is given. Then in that event, it is a normal letter that is given to the department, to the higher authority, and it is kept with the file. No receipt is given, and after finding this only, the duty rosters are being fixed, are as such fixed. So here, similarly, what happened? I intimated this, and immediately after that, my deputation working as this UDA was given to the A and B, to the examinee for the Group A and Group B of the Government of West Bengal, not C and D. Only because of the fact that I intimated that my sister is competing for C. So I was not entrusted with the job to see the tabulation sheet of C and D. Rather, I was given with the entrustment, my lord, for the job of A and B of the Government of West Bengal's service. My lord, I'll just try to, my lord, paraphrase, my lord, whatever has been said by this authority, this petitioner before your lordship. Page number 210, it starts. It starts page number 210. But page number 211, my lord, I'll just request your lordship to see. My lord, I'll just abruptly show your lordship some of the defense that I have taken. Page number 211 on 33639. My lord, 9th line from top. 11th line from top. Left hand side, the line starts with I state that. Has your lordship got this one? I state that I had specifically mentioned.
Yes, got it.
Great.
As per the practice prevailing, no receipt copy is given.
Yes. I state that charges concocted. I state that has specifically mentioned I had informed the Deputy Secretary Commission, whom I am subordinate writing, about appearance of my married sister who got married nearly 10 years back. The instant examiner, as such, I was required to act by the higher authorities as dealing assistant only to look into the work of holding personality test and subsequent preparation of the result of Group A and Group B services and post of the said examination 2017, for which my sister was not eligible, because my sister did not, my lord, sat for the examination of optional paper 2 papers. That means she is not wanting to sit in the Group A and Group B examination. So since I intimated them that my sister is competing for C. So I was entrusted with the duty to look into A and B, not C. That is my specific contention. Now, my lord, at the bottom, lordship has already seen this, for which no official receipt is given. As per its prevailing system, the office of the commission official receipt of communication letter is given only when such communication letter is submitted to the reference section office, and I was not required to submit any letter communication containing any such information. Then, my lord, skip over 3 lines on the next page, 212. Fifth line from top, it says, I also, in the middle, my lord, the line starts, I also state that submission of information in regard to appearance of my sister in the said examination of 2017 is self-evident from the fact that I was not allotted or assigned any work relating to Group C services and post in which my sister was eligible, and I was allotted only the work relating to A and B services for which she was ineligible as stated herein before. That is my specific contention, and my learned friend, my lord, will be taking to your lordship if anything contrary is proved in the entire disciplinary proceeding. It is no document or nothing is proved that I was entrusted with the job of C. It is a situation which is basically, my lord, admitted by in several other documents that I was looking into the job of A and B, not C. Now, my lord, I will just take your lordship to page number 213, article of charge, second article, which I tried to deal with. Page number 214. My lord, here in the second paragraph, I have stated, this second paragraph only I will be placing your lordship. This will be important with respect to this article of charge, page number 214. I also state that the authorities are predetermined for certain unknown reasons to make me victim of the situation, and that is evident from the fact that while issuing the memorandum of charge sheet, the secretary has dealt with my contention and statement in my reply dated 9th of March 2019 to the show cause notice of such and such, and come to the finding with certain observation that my contention and submission are not satisfactory and acceptable to the commission. That is a purely point of law. I have taken this point in my reply because in the charge sheet itself, when you have specifically stated that the defense that I have taken in the show cause, it is not at all believable, it is not believed, and you are accordingly charge sheeted. That means it is already predetermined that you are going to impose the punishment. My lord, kindly go on this, my lord. I tell your lordship, such instances are he cannot absolve himself of the charge on the plea or mere non-signing of the merit list when it is evident that he did all computer-related works and processing of data received from Weibull and generated tabulation sheet and merit list of the candidate interview, and he did not produce any, he is, my lord, quoting the charge. He did not produce any document in support of this claim, and he informed the deputy secretary about the candidature of sister in the examination. This clearly demonstrates that the respected disciplinary authority in the office of the commission is already predetermined to make me a victim of the circumstances. I, as a dealing assistant, here, my lord, is coming to the merit of the second charge. I, as the dealing assistant, was allotted to and entrusted only with the work relating to holding and personality test and preparation of result of A and B services of said examination. I state that the final tabulation sheet, it is important, my lord. I state that the final tabulation sheet of the instant examination was prepared and furnished by Sri Sumon Rai Chaudhuri, assistant manager of Weibull, via email ID of such and such, and the least candidate to be called for personality tests for Group A and B services, and the program of personality test of A and B services was drawn up on the very day itself by team, including myself and 2 IT experts from Weibull. I also state that the assistance of the above mentioned IT experts from the Weibull, which is the nodal agency of the Government of West Bengal for Information Technology Department, was made available to me by the office, as it was in the knowledge of the higher authority that I am not an expert in processing and tabulating such large amount of computerized data. Keeping this in view, the specific charge of secretary that it was my duty to process the data received through email from Weibull and other agencies from tabulation or preparation of the merit list in different stages of examination is evidently concocted, motivated, and again based on the statement as interested parties. I am not an expert in computer information technology. In any case, my designation in the office of UTA does not require me to be an expert in the computer information technology either. Then I'll skip it over. My lord, I have also specifically taken the defense that I was basically absent when this group C services examination and this this procedure was being taken place, which is at page number 216. But I did not need to take your lordship to this because I was never interested with group C job. Then my lord, 217, the second paragraph, if I just place your lordship, I thoroughly reiterate and state I was not allotted and such. Skip over, my lord. In the middle of second paragraph, the line starts. I specifically state that. It is evident from the office records and files that it is, my lord, annexure 3 in the memorandum of chart, that Koruna Mollik, upper division assistant, was the dealing assistant for group C related works for the said examination of 2017. And I had no business or authority in encroaching upon her duties whatsoever. Then, my lord, again, the entire thing. So, my lord, this has been, my lord, my specific averment and reply to that effect. My lord, needless to mention that this explanation, my lord, or this reply to the show cause, my lord, did not, my lord, go into the ear of the disciplinary authority. And finally, my lord,
it is your stand.
It is my
So
stand.
what inquiry officer held?
Yes.
Take me to the
So, my lord,
report or
page
finding of the inquiry officer.
Page number 293 of the second this thing part. Or the
29
part 2 of the paper book, read petition.
Huh?
Volume 2 of the
Yes. 293.
293, my lord, is the inquiry report.
Inquiry report. Now, specific
Yes.
these two charge. First, in respect of first charge, your stand is that I inform that
Yes.
as per the practice,
Report.
prevailing practice, no receipt copy is given.
Right.
And henceforth, in this case also, no receipt copy has been given. But I had informed.
Yes. Another thing, my lord, I just must bring to your lordship's notice before I take your lordship to the inquiry. My lord, kindly sees once my reply. My reply to the affidavit in opposition that they have used. I have, my lord, annexed a document which subsequently I got. It is an official document. Kindly seize that once.
Whether it was brought on record during inquiry proceedings.
I am sure not.
So how court can look into?
My lord, yes.
Huh?
Yes, my lord.
You should have brought on record.
Because I had a conference with my client.
By giving evidence. By giving evidence before the inquiry. It's just like you say, unless it is accepted by the court as evidence,
yes.
Appellate court cannot look into.
Cannot. That is true, my lord. But still,
yes.
I have, my lord, pleaded that and I have annexed that in the affidavit in reply last, but 106 number page.
106. Yes.
This is why, my lord, lordship will kindly see my lord's last order. If when this matter was earlier taken up by this honorable court, I made a request to my learned friend to get instruction, my lord, to this effect. That was recorded in your lordship's order.
Taking instruction, lordship, in this matter, I shall.
Huh?
I have all because this document has been disclosed in the affidavit in reply. I had no occasion to deal with that.
Yes.
And this document was not the part of his defense.
Yes, that has also fallen from you.
I have taken instruction on this.
Yes.
While making my argument, I shall deal with this.
Yes.
So, 106 says that with reference to the PUD, as desired by the higher authorities, Sri Bhattacharya UDA may be directed to carry out the duties of dealing assistant for holding the personality test and preparation of result of A and B services. Furthermore, as desired by the higher authority, Bhattacharya may not be assigned any duties in connection with C and D services, as his married sister such and such is an eligible candidate for C and D services and for the post of the said examination. So, my lord, admitted position, I did not bring this document, my lord, in any evidence before the inquiry officer, because in fact, my lord, my client specifically said that he did not have this document then. Some of his, my lord, friend who is still working in this particular organization has subsequently supplied it. Be that as it may, my lord.
Okay, be that as it may, and even if it is said that
Yes,
the first charge
Right.
is not proved or first charge.
Right.
Second, in respect of second charge, admittedly, the marks enhanced in respect of 5 candidates, the marks enhanced or there was a manipulation of the marks. Manipulation, admittedly.
Yes.
Group C and Group D. Now, you have to prove that the data regarding Group C and A was not are not available to you.
My lord, that I have, I just tell your lordship.
Although you are preparing the tabulation sheet, etc., everything, and in respect of Group A and Group B, but the data relating to the candidates belong of Group C and Group D are not available to you.
My lord. My lord, kindly sees my lord inquiry report, which is at page number 293.
290?
293 it starts.
Yes.
Yes. So it ends, my lord. The conclusion is at page number 323. So now I'll just take your lordship.
The relevant portion.
Yes, relevant portion.
So charge number 1 is proof because if there is no document, you could not substantiate your claim that you had informed.
I could not, my lord, produce any document to that effect that I inform. But on this, my lord, my submission, as has been and as also before the inquiry officer, is that the circumstances, because my lord, it is my lord not a positive act. It is a positive act, my lord. I just cannot. I do not have the receipt of the same because the office does not give in the receipt of this internal office communications. But the circumstances, it has to be, my lord, judged on the basis of the circumstances. The circumstances clearly showed that I was given with the benefit of C and D, A and B, not with respect to C and D. That means, my lord, immediately after when I informed this, then only this particular situation, my lord, brought to the notice of the authority, and authority thought it expedient that this individual has to be given the responsibility of A and B, not C and D. So that assertion, that circumstance, my lord, proves that I have already intimated that. I'll just take your lordship, my lord, to the inquiry authorities. All right, here, page number 299, article 1, page number 301, where all this, my lord, submission of mine have been, my lord, recorded. My lord, here, lordship will see page number 305. Page number 305, your lordship will see.
Yes.
All right, it is.
Yes.
It is the evidences. I'll not take your lordship to all the evidences because all the evidences are in the same line that I am the only responsible person, as if I was the only man, my lord, who was taking the examination of PSC. I'll just take your lordship to the procedure. Evaluation of the evidences. This is at page number 312. My lord, page number 312, my lord, sees.
Page number
312. Evaluation of the evidences. My lord, here, after article of charge, now Kaushik Bhattacharya suspension submitted in written defense.
Yes.
Sri Bhattacharya, next page. Sri Bhattacharya claimed in self-defense that it would never have had been possible for anyone to be reported to the secretary himself to have suddenly learned that Somnatta Ganeriwala, because it is all the circumstances I tried to prove before the inquiry officer, that unless I informed, I intimated to your officers, it would not have been possible for the secretariat to know that my sister is sitting in the examination. Sri Bhattacharya claimed in self-defense that he would not have been possible for anyone to have reported to the secretary for the such and such. Indeed, his sister, had he himself not informed the authority, but he failed to produce any document in support of his claim. Sri Bhattacharya, charge official in his deposition, submitted that he kept written applications January 17, cross-examination on the table of Gautam Bosak, the deputy secretary of such and such. But Sri Gautam Bosak, the deputy secretary, confidential section submitted in his deposition that Sri Bhattacharya informed him nothing regarding appearance of his sister in WBC examination, and Sri Bhattacharya kept no letter in his regarding this section. He further added that he came to learn it after retirement from the newspaper. So Sri Bhattacharya Chadave submitted that the receipt of the letter are given in the reference section. If letters are submitted there, then why he did not submit the letter to the reference section is not clear. That was not at all difficult for him to the reference section. He is very much within the same campus of the PSC. In all previous cases where relative of PSC appeared in the examination, exemption prayers were submitted to the secretary and exemption orders were issued during hearing. Two such cases have been placed by the presenting officer, M. Dotto Roy and Midi Besra, where, my lord, they have intimated that they should be exempted. It is evident that Mili Besra, confidential section, being the same rank and same officer, had applied to the secretary for exemption. The claim of Kaushik Bhattacharya, the charge officer, that as per the system prevailed, intimation is to be given to the next higher authority is not clear. He could not produce any document or persuasion for getting exemption order. The charge officer submitted that in his self-defense, exhibit number 4, page 3, that the submission of information in regard to the appearance in his examination is self-evident from the fact that he was not allowed or assigned any work relating to the Group C services in which his sister was eligible and was allotted only the work relating to Group A and B services and post for which she was ineligible. Now, if he submitted any intimation to the commission before the said preliminary examination, the commission definitely exempted him from responsibility of all groups A, B, C, D, as was done in case of Dotto Rai, confidential section. Why should the commission wait for eligibility or ineligibility of his sister for particular group or groups? Moreover, he could not show any order proof that he was not allowed to or assigned any work relating to Group C services in which his sister was eligible and was allotted only to the work relating to A and B services and post for which his sister was ineligible. Sri Bhattacharya could not produce any receipt of prayer for exemption or exemption order in this respect. So the charge against Bhattacharya confidence is established. So, my lord, here entirely, my lord, the finding of the inquiry officer also, my lord, similarly in charge number 2 is based on my inability to produce any kind of document that to show that I actually intimated them, or I could not show that I was not given with the responsibility of C and D. So, my lord, all along my stand before the disciplinary authority.
So there is a practice of not only receive from intimation from the concerned employee, but issuance of a exemption order also. That if any such letter or intimation is received from the concerned employee, then one exemption order is issued by the authority.
That I find from the evidence I follow.
Yes.
Here, my specific case, that in my case, in my particular situation, my lord, this entire things are, my lord, internal communication between the departments, including this exemption orders. Everything, because lordship has seen on the previous page this Dotto Rai's case, an internal communications memo is mentioned. So all this, my lord, are internal communications. This cannot be there in my hand because these are like note sheets, which that submission I'm coming to that effect. These are all my note sheets and my lord, all the official note sheets. And my lord, I specifically, my lord, have taken the stand all along in the entire disciplinary proceeding that my inability, you will have to prove your own case. My inability to show the particular document that I did not inform you. That was not the case because circumstance says that otherwise why the department would have, my lord, exempted me from, my lord, taking the tabulation sheet and everything with respect to C and D. This particular conduct itself, my lord, shows the department was intimated about the fact, apart from the fact that amongst this lakhs of
Reverse Berlin, negative fact cannot be asked, anyone cannot be asked to prove negative fact. It is very hard.
and this
You
entire
have to prove, yes, I intimated and this is the proof.
But since I did not have this document, I only, my lord, based on the circumstances, which, my lord, basically would, my lord, lead to the only plausible, my lord, conclusion that I was not interested with the tabulation sheet checking or putting the numbers of tabulation sheet with respect to C and D. I have been only interested to A and B, and this particular aberrament, my lord, by the inquiry officer is completely wrong. That how would I know that my sister would not qualify for A and B? Because my sister did not even sit for the optional papers. That means, my lord, she intended not to be qualified for A and B. So, my lord, this observation on the basis of which the inquiry officer says that these charges are proved or established, my lord, is that it would not have been known to the office that this lady would not qualify for the A and B. But, my lord, intentionally she did not sit for this optional papers 1 and 2. So that means, my lord, her intention was all along not to compete for the A and B, but, my lord, for the C and D only. If, my lord, the situation would have been that she sat for the examination and failed, then this could have been different. But she did not sit for the examination. She intended to be competed, my lord, for the C and D only, not for the A and B. So, my lord, here, thereafter, my lord, page number 323, your lordship will find the conclusion. And in this,
so your contention is the data relating to the group of group C and group D, and the data relating to group A and D are kept in such a watertight compartment that who is dealing with the data with A and B, he will not ever get access to the data of C and B. It is kept with a watertight compartment, and a drop of water will not go.
Why I say so, my lord? Why I say so? My lord, from the chart sheet itself, my lord will see that from the chart sheet itself, I am not taking a lordship to any of my document. From the chart sheet itself, it shows that this data with respect to the C and D, my signature is not there. My signature, because when in an office or someone is given responsibility of this kind of, my lord, importance, he has to, my lord, bear his signature in that particular sheet or document, whatever he is not examining, or he is basically putting the numbers from here to there.
Well, the employee of UD, UD has got no authority to put his signature on any document.
But it has, because I tell you, lordship, in A and B, my signatures will be evident.
So
my signatures in A and B will be evident. On the other hand, in C cases, in C and D, it is evident from the chart sheet itself that my signatures are not there. That if your lordship only sees the charge, that will do. The chart says that my signature is not there in C and D. Rather, it is there in A and B. A and B to kothay? But I have annexed the, my lord, those sheets. Sorry, my lord, the department itself, my lord, has annexed, my lord, the tabulation sheets and this thing of A and B, where, my lord, my signatures will be evident, which is in the affidavit in opposition. I'll take your lordship to that. Page number 2, page number 289 of the opposition.
Yes.
At page number 289, if your lordship wants sees from the opposition, your affidavit in opposition. Has your lordship got this? But it is with respect to my lord.
Prepared by K. Bhattacharya.
Yeah, what charges? My lord, the entire the next pages also. Now, my lord, kindly see page number. This is my lordship has seen at the top. It is written Group A services. Now, my lord, sees কত 147 না কত ছিল? Now, kindly sees my lord, page number 147
of the AO.
of the opposition. Yes.
Yes.
But this is the document of C. C services of the post. Here, my lord, there is no signature of anyone, I find.
Yes.
I won't have to, my lord, take your lordship to their document. It is only their charge sheet itself which says that this signature is not there in C and D. My lord, then my lord kindly sees the order for dismissal, which is at page number 420 of the second part of this volume. Second part of the writ petition, my lord.
Yes.
My lord, your lordship will see the order. Kindly see if your lordship will find any reasons in this. My lord, 1, 2, 3, 4, 5. Last but one paragraph, my lord, which says, whereas agreeing with the report,
Yes.
inquiry officer and considering all aspect as well as evidence, records, report, inquiry authority independently and judiciously, having regard to the gravity of the charges proved against Kaushik Bhattacharya, is of the view that Bhattacharya is guilty of grave misconduct and causing irreparable damage to the sanctity of the constitutional body like Public Service Commission, and deserves the penalty of dismissal from the service, which shall ordinarily be disqualification for future employment of the government in terms of such and such. Pursuant to this, my lord, the next page, the last but one paragraph. Whereas the disciplinary authority, after considering the representation, my representation was stated to be considered, and after considering the representation of Bhattacharya and examining all relevant documents of the case, has finally decided to impose the penalty of the dismissal from service, which shall ordinarily be a disqualification of future employment under the government in terms of such and such. So there is no other reason against this, which I specifically pleaded.
You prefer appeal?
In my appeal, yes.
You prefer appeal?
Yes, yes. Page number 422. So your lordship will see.
Page number
422. This is the appeal that I have preferred. 422.
Yes. Appeal also decided against you.
Yes. Same, my lord, reiterated. No further reasons have been given.
So your case is that the decision is based on no evidence, perverse.
Yes, perverse. And secondly, my lord, my respectful submission before your lordship, it is with respect to the first part and the second charges. They say that I have made some fabrication in this particular document. Here, my lord, I have stated that this, because these are interlinked, because I stated that this C and D job was not handed over to me, but there in the chart of those 5%, there may be someone, my lord, who may be in the A and B services. But here, my lord, I have specifically stated the point that I am not an expert in this particular tabulation sheet filling up. There are other persons who are called upon by the HON'BLE who will be assisting me for doing this. And even if, my lord, for the sake of argument, my lord, we say that it is a mistake that I have done with respect to, my lord, this tabulation sheet filling up, my lord, that would be, my lord, negligence. And that negligence, my lord, would not be of such nature that would be, my lord, giving me the capital punishment for dismissal on the service, with barring me from getting the future employment.
No, disproportionate.
Yes. Because the malafide, basic malafide, my lord, in the entire thing is that I suppressed my sister's candidature in the entire recruitment process. I submit to your lordship that in the entire, my learned friend will be showing to your lordship if something contrary is there in the entire disciplinary proceeding. It is, my lord, complete all along the case that I have intimated I do not have the receipt, but the conduct of the department itself shows that they knew about this, and this is why I was not interested with the job of the C and D, and my sister purposely sat for the examination of C and D and not A and B. So this is why, my lord, the malafide is not there. So if at all, my lord, it is believed that I made some mistake in the tabulation sheets of other persons also, apart from my sister or whatever, that would be not my own only responsibility for taking care of this. It would have been, my lord, even if it could, my lord, for the sake of argument, my lord, admitted that it is a mistake that I have done in filling up the tabulation sheet, my lord, that would not, my lord, render me in such a position that I will be given with this capital punishment. And lastly, my lord, that I have already stated before your lordship, that this order of disciplinary authority is completely without reason.
Without reason.
It doesn't, my lord, say that why this inquiry, why means, my lord, in the last paragraph of the disciplinary authorities, or last but one paragraph, it says that your representation is considered and found to be completely unmeritorious. So, my lord, nothing, why it was not meritorious, why it was not my lord, proper, that was not considered. Even, my lord, the appellate authorities order at page number 486, completely same. No reason is there, apart from accepting whatever has fallen in the inquiry reports, inquiry officer's report. My lord, I'm sorry, my lord, that was I forgot, my lord, to take your lordship to one of those last document. I'm sorry, I'll not bother you, lordship. Only last document, my lord. My lord, before all this, my lord, before this charge sheet was issued to me, there was a memo of suspension, my lord. And after this, my lord, there was a memo of suspension. Why I take your lordship to this, my lord? I'll just address to your lordship.
Preconceived mind.
My lord, page number 195 will be another
2010 Supreme Court, Oxy, suspension. You will take me to the order of suspension.
Yes.
Page
194, and then lordship knows, my lord, what I say, and then, my lord, 195 also. 195 only, my lord. I'll just take your lordship's one paragraph of this memorandum, which is not even a charge sheet, which is dated 6th of March 2019, my lord, of the volume 1.
194. I am going to 194.
Yes.
4.
4, I'll not take your lordship to. Lordship
Yes.
195, lordship sees. It says first, second, third, fourth paragraph. It says, my lord, it says that first paragraph says in an act of tampering with the data and manuals and fabricated manuals such and such. Fourth, and whereas such act on the part of Shri Kaushik Bhattacharya are unsuitable and for not fitting or becoming a public servant and are in gross violation of sub-rule 253 of West Bengal Service Duties Rules of 1980. Read with such and such. But this is even before issuance of the charge sheet. This is even before issuance of the charge sheet, at the stage of suspension. This is all, my lord. Thereafter, my lord. But my lord, to substantiate of this submission of myself, my lord, if I request once again, my lord, to take your lordship to page number 205, the charge sheet, the article of charge.
Yes.
My lord, the preconceived mind, your lordship will see the last paragraph of page number 205.
Yes.
It is evident. So, my lord, it is already evident that Kaushik Bhattacharya, presently under suspension, has manipulated and fabricated the marks of the above 5 candidates with ulterior motive to make them eligible for interview and selected in the final merit list. So, my lord, whenever they are using this term evident, that means that is a conclusive decision after considering every evidences or whatever they have right now. So, it is already evident at the time of charge sheet itself that I have committed this particular wrong. এটা কোন আমাদের পিটিশন তো এটা অপোজিশনের রিট পিটিশন মানে লর্ডশিপ has seen the tabulation sheet of group C in my opposition page number.
Your signature is not there.
It's not there, but signature of someone else is there.
Yes, yes. Signature of someone.
Page number 194.
Yes. Yes. That's all.
That's all. Well, I'll just supply your lordship one judgment that I was referring to, one paragraph.
Justice Ashok Ganguly. Justice. Oxy or such and such.
That my lord I have. Okay, let my learned friend my lord. I'll just take your lordship to that.
Yes.
May I reply on the next day, Lordship?
No,
Because
yes, simple matter. He has not said any.
many things to place also, Lordship.
Charge number 1 is he did not intimate.
Yes, Lordship.
Charge number 2 there is that he got the opportunity to tabulate and all the numbers such as the data, and then he manipulate the numbers of 5 candidates. 5 candidates. His defense is that he intimated this fact, but you have not issued any receipt, and taking note of this fact that his sister is going to appear, you allotted or assigned the work relating to group A and B, not C and D.
Lordship, the case of PSC is that he was in charge of all the groups. And there was no intimation regarding his sister appearing in this examination, Lordship. That is why they could not disclose the letter ever. Lordship, I would like to, I have disclosed the scheme of the examination, all the deposition, day-to-day note sheet, everything before the Lordship in respect of his petition, Lordship. I would like to place the inquiry report in its entirety, Lordship.
In his entirety?
Yes, Lordship, because they have agreeing with the report of the inquiry officer. So it is very important to place whatever.
Yes, inquiry officer, but not entirety. Yes. Start from page 293.
293.
Yes.
After that, I'll come to my opposition, Lordship.
Yes.
Discussed
Yes,
the scheme of the examination and how he has manipulated. So I'm reading from page 296, Lordship. The defense which they have taken, first I'll go to the defense, then the prosecution.
Yes.
First of all, Shri Kaushik Bhattacharya, UDA, PSC WB, presently under suspension. The charged officer was asked by me in presence of the presenting officer whether he has received the charges framed by the PSC WB against him, wide memo so-and-so, dated so-and-so, along with all the enclosures. He acknowledged in presence of the presenting officer the receipt of the charges along with the enclosures. The charges were then read over. These are the formalities, Lordship.
Such and such, yes.
Lordship. Then, Lordship, the relevant point from the self-defense submitted by the Kaushik Bhattacharya. I'm not going into the charges, article of charges, which he has already placed. That he had informed the then deputy secretary. To him, he was subordinate in writing about the appearance of his married sister before holding the preliminary test of WBCS executive examination 2017. No receipt was given. No letter was ever found, Lordship. Had he disclosed the appearance of his sister in this examination, he would not have been given the charge of the tabulation sheet, preparation of merit list, etc., Lordship. That as per system prevailing in the office, such information is to be submitted to the immediate higher authority by the concerned incumbent, for which no receipt was given. That is his defense. That official receipt of any communication letter is given only when such communication letter is submitted to the reference section. Question of receipt comes because he has not given any letter. That he was not required to submit the letter to the reference section, and so the question of receipt does not arise. The submission of information in regard to appearance of his sister in the said examination 2017 is self-evident from the fact that he was not allowed to or assigned any work relating to Group C services in which his sister was eligible, and was allotted only the work relating of Group A and B services and post for which she was ineligible. Lordship, here I would like to take a pause. He was showing the tabulation sheet of Group C where the signature is not found. Why the signature is not found? The entire tabulation sheet was missing. Even after best of the efforts, the tabulation sheet could not be found. After that, the commission has got it from the Weibull itself. These are the computerized data received from the Weibull. I have taken all these points in my opposition, but thought I should mention here. Next, my lord, page 297, that his sister married 10 years back and she applied in 2017 examination as Somdatta Generiwala and not as Somdatta Bhattacharya. That her parents and permanent address in the examination was her husband's address and not his address. That in any official document or record, there is no mention that she is related with him. That keeping those factors, it is quite obvious and evident beyond any doubt whatsoever that it would never have been possible for anyone to have reported to the secretary, or for the secretary himself to have suddenly learned, or for him to have surmised that Somdatta Generiwala was indeed his sister, had he himself not informed the higher authority. That the entire charges were concocted, false, and smacks of malafide is against evidence. Now he has denied all the charges, Lordship. Now regarding the charge number 2, Lordship, that he clearly stated that he was not designated dealing assistant for Group C. This examination was in entirety, Lordship. As such, he was not required to play any role as regard Group C of the instant examination concerned. That the final tabulation sheet of the instant examination was prepared and furnished by Shri Shuman Roy Chaudhuri, Assistant Manager Weibull, on 12 January 2018 via email ID of Deputy Secretary. That the list of candidates to be called for personality test for Group A and B services and the program of personality test for Group A and B services was drawn up on that very day by a team including himself and 2 IT experts from Weibull. That the work of conducting the proceedings of different examination under the purview of confidential section was evenly distributed among all UDAs, LDAs, and other higher officials, that it was unbelievable and impractical that he himself, a single UDA was in charge of processing, tabulating, and preparing merit list of all examinations, which also suggests that other LDCs, UDCs, HAs, SOs, AS, DS, and other higher officials had no work at all in connection with the said examination 2017, because he was himself entrusted with that preparation of tabulation sheet, merit list, etc., because he was expertise in computer. That he was allotted to and entrusted only with the work relating to holding of personality test and preparation of result of group A and B services of the said examination. That he had prepared the note sheet containing the tabulation sheet and merit list of group A and B, put his signature on the note sheet, which was mandatory, and signed on the note sheet. That he was not allowed to and entrusted with the then he did not perform any work including computer related job, preparation of tabulation sheet and merit list, etc., relating to group C services and post of the said examination 2017. That he was absent in office at the time of personality test of group C of the instant examination, and it was evident that he was not in charge of any work related to the same. That Srimati Koruna Mollik, UDA, was the dealing assistant of Group C related works of the said examination 2017, and note containing the tabulation sheet, merit list, etc. for the said examination was initiated and prepared to by her and bears her signature. The absence of his signature in the file of Group C services and post-examination 2017 clearly evident that he was not allowed to and not entrusted with the job, work or preparation of annual tabulation sheet, merit lists, etc. in connection with Group C services and post of the said examination 2017. Your Lordship, I would also like to mention that not only him, few other persons have already been showcaused. I have enclosed the deposition of all because it is very important to see what they have said in their deposition. That the list of candidates called for personality test for Group C service was prepared by the leading assistants, and relevant note in the file was also signed by him, her or them. That he did not prepare any program of personality test of Group C for the said examination 2017. That as such, scope of himself fabricating or manipulating anything, including marks of any candidate in any document related to Group C services and post of the said examination 2017 does not arose at all, and there was no lack of integrity, impartiality, and devotion to duty, and there was no violation of Rule 3 of WBS DRO Rules 1980, read with WBPSC Condition of Service and Miscellaneous Provision Regulation 1953 on his part. I will place all these regulations, Lordship. That the said email ID of Deputy Secretary was created by him 5 years ago, connecting his personal mobile, as the Deputy Secretary at that time did not know how to create an email ID. That the Deputy Secretary himself and several LDAs, UDAs, section officers, Assistant Secretary used to use the said email ID, that it was kept signed in form of the PC in the chamber of Deputy Secretary and Assistant Secretary at most times, so that anyone using that PC could access the said email ID under reference. That the said email ID may had inadvertently been used by him, as his personal mobile phone number was linked, but he failed to understand how having used it inadvertently for personal purpose could translate to fabrication and manipulation of marks in Group C services and post of the said examination 2017. That he had provided tabulation sheet of all candidates who appeared in the WBCS executive, etc. main examination 2017, which consists of Lordship Group A, B, C, and D. To the PA of Chairman, as asked by the Secretary and the Honorable Chairman, that he just provided the printouts as it existed in the computer of the Deputy Secretary at the end of January 2019. That it was quite obvious that the events of tampering had taken place much before holding the personality test of Group C, that is his assertion. That is before October 2018. That it was obvious that the printout of tabulation sheet taken in January 2019 was obviously contained those tampered fabricated marks. That he was asked to provide printout of tabulation sheet of all candidates who appeared in the WBS executive etc. main examination 2017 and not specifically the candidates who appeared at the personality test of Group C further corroborates the fact that he was not at all in the charge of proceedings related to Group C services and post of the same examination, that he was in knowledge and higher authority. As such, question of manipulating and fabricating anything, including marks of any candidate related to Group C of the said examination, does not arose at all. Now, Lordship, I come to the deposition. Points taken from the deposition of Kaushik Bhattacharya. That Shri Kaushik Bhattacharya admitted that he was the UDA attached to the confidential section of the Office of the Public Service Commission, West Bengal, and now under suspension. That regarding the point that the time of preparation of final merit list of eligible candidates for the WBCS Executive etc. examination 2017 Group C services and post, it came to the notice of the office that one candidate, namely Somdatta Ganariwala, daughter of Dwijdas Bhattacharya, featured in the merit list. The submission of Shri Kaushik Bhattacharya was that he had no idea. He was not in charge of preparation of merit list of Group C as West Bengal Civil Services 2017. Had he was not in charge of the Group C examination, Lordship, he was well aware that he is in charge of this particular examination. Shri Kaushik Bhattacharya admitted that Srimati Ganariwala is his sister. That Kaushik Bhattacharya denied that he did not inform the commission that his sister is a candidate for WBCS Executive etc. examination 2017. His submission was that on 17 January 2017, he had informed the then Deputy Secretary of Confidential Section, and that was the only reason that the authorities could know surely that Srimati Somdatta Ganariwala is the sister of Kaushik Bhattacharya. That regarding the point that Shri Bhattacharya, in his reply to show cause, intimated that he had informed the Deputy Secretary of the fact that he did not produce any document in support of his claim, that he informed the Deputy Secretary about the candidature of his sister in the said examination. Shri Kaushik Bhattacharya admitted and submitted that he was not given any receipt, and so producing the same on demand was not possible. That regarding the point that such failure on the part of Shri Kaushik Bhattacharya is complete violation of Rule 3.5 of WBS DRO Rule 1980, read with WPSC Condition of Service and Miscellaneous Provisions Regulation 1953, and tantamount to dereliction of duty. Shri Kaushik Bhattacharya denied and submitted that he was simply in charge of some clerical works and not called upon to decide any matter. As such, Rule 3.5 of DRO Rules 1980 does not apply to him. Moreover, there was no such provision in WPSC Regulation 1953 which makes it mandatory for him to inform office regarding candidature of his married sister. Lordship, kindly note this point. It is not mandatory for him to inform office regarding candidature of his married sister when he is in charge. He was in charge of the particular examination. And others employees have received exemption certificate, Lordship. He has not given him even the exemption certificate.
Okay, most of the witnesses have deposed that yes, the computer related work even for the group C candidates are entrusted with the delinquent employees.
Yes, Lordship.
And most of the witnesses have said.
Yes, Lordship. And just because the tabulation sheet was missing, we had to, commission had to get it from Webble. In other tabulation sheet, I have disclosed each and everything, Lordship. You will find that his signature is there. He was completely entrusted in regarding the preparation of tabulation sheet, merit list, etc.
Yes.
Now, Lordship, in respect of article of charge number 2, that regarding the
according to sufficient evidence available,
sufficient evidence
available on the record to conclude that he was in charge of preparation of such and such,
and the commission has maintained the transparency, disclosing each and every document. I will show from the evidence itself, Lordship, from the deposition.
The deposition I have seen up to.
No, Lordship, in my deposition also, I have disclosed each and everything, day-to-day note sheets, order sheets, each and everything I have disclosed. That there was the inquiry proceedings has been conducted in accordance with law, and it's not that
This is not his case. There is any procedural irregularity or not, which is the main concern of a court exercising power of judicial review, that there is a procedural irregularity. But in the given case, it's not case. It is not his case. Is that decision is based on no evidence.
No, Lordship, the decision is based on the inquiry report.
And
they have agreed with the inquiry report, and the inquiry report is elaborated inquiry report. It's not that the inquiry officer has vaguely written something. The inquiry officer has gone into each and every facts. That's why I would like to place the inquiry report completely, Lordship.
And another fact here that you proceeded with a predetermined mind.
That is not the case, Lordship.
The word evident, you come to that.
Yes, evident. Why it is evident? Because they have found on inquiry. They have found on inquiry. Initially, they have come to a finding that the after getting the tabulation sheet from Webble, that there's a huge discrepancy. And he was in charge of everything. And when they came to know that his sister was one of the candidates, he has not disclosed it. That is why the word evident has been written, Lordship. It is not regarding the predetermined, any notion that they will act against him. Otherwise, so a lengthy inquiry would not have been gone. In a government organization, they have maintained each and everything, Lordship. Can I raise the case on the next day, Lordship, now?
No. You conclude.
Now, Lordship, regarding the article of charges number 2, that regarding the point that Shri Kaushik Bhattacharya, UDA PSC WB, presently under suspension, were attached to confidential section of the Office of Public Service Commission, West Bengal, and as dealing assistant, his duty was to process the data received through email from Webble and other agencies for tabulation and preparation of merit list in different stages of examination. Shri Kaushik Bhattacharya admitted that he was attached to the confidential section, but denied that his duty was to process any data received from Webble and other computer agencies. That regarding the point that he was also entrusted with the computer related works, for the purpose, Shri Kaushik Bhattacharya denied and submitted that he was not entrusted for the said purpose. That regarding the point, as per prevailing system, Shri Kaushik Bhattacharya had free access to the email of the Deputy Secretary, where the result of different examination was received from Webble. And other agency, Shri Kaushik Bhattacharya admitted and submitted that he had access to the email ID of Deputy Secretary.
Deputy Secretary, yes.
Yes.
এবং he used his registered mobile number also. Result was sent on his mobile cell phone.
And he was aware that his sister is appearing in Group C services and he is accepting
all the
results on the computer.
Yes.
Shri Kaushik Bhattacharya admitted and submitted that he had access to the email ID of Deputy Secretary along with several others, including Deputy Secretary and AS themselves. That regarding the point that even it was reported that the said email of Deputy Secretary was opened by him with his mobile number as registered mobile number, it was also evident that he used the said email for his personal purpose. Shri Kaushik Bhattacharya admitted and submitted that was in no way related to fabrication of marks. He was in charge of everything, but he was not aware of the fabrication of marks. That regarding the point that Shri Kaushik Bhattacharya, UDA, presently under suspension, processed the marks of 6 compulsory and 2 optional papers as was received from Webble for WBCS Executive Examination 2017. Shri Kaushik Bhattacharya denied and submitted that he was not in any such charge. Here, Lordship, it is written that all 6 compulsory and 2 optional papers. That regarding the point that Shri Bhattacharya generated a working list in hard copy from the computerized data with the candidates to be called for personality test of Group C services and post and provided the same to the confidential section for necessary action. Kaushik Bhattacharya denied and submitted that he was not in charge of any work related to Group C and he had no business or opportunity to encroach upon the responsibility of Shri Kaushik Saha. He is another person, Shri Kaushik Saha or Srimati Karuna Mullik, who were the designated dealing assistant for Group C. That regarding the point, he held also prepared a detailed program of personality test for the said examination. Accordingly, the candidates were called for interview. Kaushik Bhattacharya denied and submitted that he was not in charge stated above, whereas all the tabulation sheets came together. That regarding the point that interview marks of the candidates were checked by the said section and handed over to Shri Bhattacharya for tabulation. Shri Bhattacharya prepared the tabulation sheet comprising total marks of 6 compulsory papers and interview marks with aggregate in respect of 1245 candidates. He also prepared a general standard merit list and relaxed list arranged according to rank on the basis of the tabulation sheet and handed over the same to the dealing assistant of the confidential section. He again denied it. He said it is the complete responsibility of the dealing assistants. That regarding the point that accordingly marks of the candidates in the merit list as prepared by Shri Kaushik Bhattacharya presently under suspension were verified with fresh tabulation sheet obtained from Webble. Shri Kaushik Bhattacharya denied and submitted that no such list prepared by him. That on verification, it was detected that the marks of following candidates have been fabricated. The names of the candidate have been given, including his sister. Roll numbers has been given, marks in the merit list, which was in the merit list, and the marks as per Webble tabulation sheet is also been given. Lordship can see the differences. Shri Kaushik Bhattacharya made no comment and submitted that matter as record. This is as matter of record. Shri Kaushik he has not even denied it. Shri Kaushik Bhattacharya admitted that the candidate Somdatta Generiwala is his sister. That regarding the point that even Shri Kaushik Bhattacharya provided a tabulation sheet of all candidates who appeared at the main examination of WBCS examination 2017 to the PA of the chairman, and it is evident that the marks of the above 5 candidates have been fabricated in the said tabulation sheet. Shri Kaushik Bhattacharya admitted and submitted that a statement of printouts of marks taken in February 2019 would contain the fabricated marks as they were reported fabricated before September 2018. That regarding the point that Shri Kaushik Bhattacharya, presently under suspension, has manipulated and fabricated the marks of the above 5 candidates with ulterior motive to make them eligible for interview and selected the final merit list. Shri Kaushik Bhattacharya denied and submitted that he had no association to do such work, as he was not connected to do such work as was done by the dealing assistant of Group C of the instant examination. Such act of fabrication is clear instance of misconduct, fraud, as well as lack of integrity, impartiality, and devotion of duty on the part of Shri Bhattacharya, which is clear violation of Rule 3 WBS DRO Rules 1980, read with WBPSC Condition of Service and Miscellaneous Provisions Regulation 1953. That regarding the point that Shri Kaushik Bhattacharya, presently under suspension, stated in his explanation that he did not act as dealing assistant in the instant matter and did not sign the merit list of Group C services, and post the said examination, Shri Kaushik Bhattacharya admitted and submitted the matter at record, and facts would clearly evident from the related documents and files. Very surprisingly, this Group C tabulation sheet was missing. The explanation given by Shri Kaushik Bhattacharya is not satisfactory and accepted by Commission. That regarding the point that he cannot absolve himself of the charge on the plea of non-signing the merit list when it is evident that he did all computer-related works and processing of data received from HON'BLE and generated tabulation sheet.
Okay, yes. Yes, got it. Yes. Now the next point, yes.
Now, Lordship,
So,
prosecution.
so the inquiry officer, based on the convincing evidence placed before it, has concluded that the charge level against the petitioner had been proved.
Yes, Lordship.
Yes.
Now, Lordship, I will come to the prosecution case. What are the other documents and what are the...
Read it, I have written already. In this way, reading is to be to some extent different. Suppose Ram has committed murder, killed the Sam with a knife. If you read 4 words, entire sentence will be read. Ram, Sam, murder, knife.
Lordship, I would not have gone into so much unless it was a disciplinary proceedings.
Am I clear? Am I clear to you? Suppose there is a long sentence, the Ram has such and such, has caught him, such and such, and ultimately Ram has killed the Sam with a knife. You read Ram, Sam, murder, knife. Everything is clear to you. Okay, you have to read in this way. Okay, I've got next point, next point. We are approaching to 4, yes. Any other point? Yes. So, yeah. Accordingly, the disciplinary authority has agreed with the situation at all. So, no details reason is required to be given, Mr. Roy, why he has agreed. And law says, and there is judgment of the Supreme Court, no details reason should be given.
Yes, I'll be relying upon one judgment when it implies only one line. That
Shiv, I need to...
Yes. 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 Yes.
I'm sorry, Lordship, I'm taking much time.
No,
It is a disciplinary.
no,
proceeding.
yes.
Want to
I
make
have
out-
written, most probably all the witnesses conjointly voiced
Yes, Lordship.
that the petitioner was entrusted with the job, computer-related job, for preparation of tabulation sheets, etc.
Yes,
Yes,
Lordship.
yes, yes.
Lordship, here the deposition has been summarized, Lordship, which
Yes.
I have also disclosed in the affidavit in opposition, just to substantiate that on the basis of the deposition only this inquiry report has been prepared.
Prepared, yes, yes,
Just to maintain the transparency, I've
Yes.
disclosed everything.
yes.
Only regarding the Kaushik Saha, the system analyst, his
Yes.
yes, I would like to submit, Lordship.
Yes, yes, yes.
That this is Kaushik Saha.
Size PW,
System
PW,
3.
PW3. Yes.
That he is the head of IT cell of the commission, and Shri Bhattacharya was associated with the confidential section of the office, that there was no direct association between two departments of the commission, that he is not able to opine regarding the internal work procedure of the section, that technically it is possible to update the result Excel file after downloading from the email ID and then the same to have fabricated. However, it is not possible to comment regarding the person who did the job. He has just stated whether it is possible or not, being the system analyst. That the email ID which Webel sent the results copy
Yes.
was registered with Sri Bhattacharya's personal mobile number.
Mobile, yes.
And the same was used for his personal purpose as well. That various personal chats, screenshots, and other personal emails were also found in the said email box of the said email ID. Now, Lordship, Shri Niladri Kumar Roy, he has in point number 2, he has stated that he with Shrimati Gupta checked and found that marks of 5 candidates were to a high extent in the above mentioned 4 compulsory papers in the merit list in comparison with the results supplied by Webel. All these discrepancies were appeared after the Webel supplied the tabulation sheet, Lordship. Now, GX Deputy Secretary has stated whether
Work, yes.
So they will move to verify whether original or fabricated. And That all wrong computer related services were done by downloaded by people are copies were provided to the respective meeting as per position. Only person who has downloaded it and given to the dealing officers, as he has alleged that the dealing officers were in charge of that. The list of candidates who were eligible to be called for interview for Group C was sought from Kaushik Bhattacharya confidential section, but he declined to serve it as first. And when the then secretary, Ms. Mukuta Datta, insisted to have the said list, Mr. Bhattacharya agreed and supplied to Ms. Mukuta Datta where the names of the candidates, roll numbers, and total of compulsory papers were provided in printed form. That on the occasion of handover the list, he accompanied Sri Bhattacharya and Assistant Secretary of the section. That the list was provided to the higher authority bypassing relevant tiers of the sections. Now the Assistant Secretary has also deposed.
Also deposed and said,
Yes.
yes, computer.
Yes.
That means this what found, this statement found corroboration from other witnesses also. Okay.
PA of the chairman has deposed
Mhm.
that he has handed over the sealed cover.
Yes. Yes. Released today. Yes. Really. Yeah.
Now, Shri Kaushik Shaha of the confidential section has also stated that all the data as required for intimation of file number IC 31/2018 to call the candidates to be interviewed in connection with WBCS Group C services and posts were exclusively furnished by Kaushik Bhattacharya. What he had mentioned in note sheet 2 of the said file. That on 13th February, when he was absent in office, he sent data in email of the Deputy Secretary, confidential section, to download the précis of the candidates who were called to interview in connection with the WBCS Group C PT examination 2017. Though he was absent, through email he has sent all these things. So, Lordship, all these depositions corroborates that he was in charge of all the examination and he was deliberately not disclosed that his sister
Wife
is
is also appearing in the or participating
yes, Lordship.
appearing in the examination. Yes.
Now, Lordship, may I place evaluation of the evidences? (313), Lordship, page 313, second last paragraph. In all previous cases where relatives of PSC employees appeared, your Lordship has also marked this paragraph. Appeared, exemption prayers were submitted to the Secretary PSC. Accordingly, exemption orders were issued. During hearing, two such cases, placed by the presenting officer. Number 1, prayer of Srimati M. Datta Roy, dated so and so, addressed to the secretary for appearance of her daughter at the same examination and for the same year in question, 2017 WBCS preliminary. It was considered, exempted her and transferred from IT cell. Prayer of Mili Besra, UDA, confidential section, addressed to the secretary PSC for exemption of why the petitioner given letter regarding disclosing the candidature of the sister. He is in charge of the entire tabulation sheet. He is taking care of the entire computer data. He will not be exempted. It is evident that Mili Besra UDA confidential section, being the same rank and same section of the Sri Kaushik Bhattacharya, the charged officer had applied to the secretary for exemption for appearance of her niece in an examination, whereas the petitioner could not produce any such.
Yes.
So the claim of Sri Kaushik Bhattacharya, the charged employee, that as per system prevailed, intimation is to be given to the next higher authority is not clear. He could not produce any document of persuasion for getting exemption order. Sri Kaushik Bhattacharya, the charged officer, submitted in his self-defense statement, that is Exhibit 4, that submission of information in regard to appearance of his sister in the said examination 2017 is self-evident from the fact that he was not allowed to or assigned any work relating to Group C services in which his sister was eligible and was allotted only work relating to Group A and B services and post for which she was ineligible. Now, if he submitted any intimation of the commission before the said preliminary examination, then commission definitely exempted him from responsibility of all the groups A, B, C and D, as was done in case of M. Datta Roy. Confidential section, why should commission wait for eligibility or ineligibility of his sister for particular group? Because she has chosen Group C as an option. Along with Group A and Group D. In my opposition, I have given that petitioner's married sister Somdatta Ganeriwala was a candidate of said recruitment examination who exercised her option choice for Group A, Group C and Group B services and posts. Sri Kaushik Bhattacharya could not produce any receipt of prayer for exemption or exemption order in this respect. So the charge that Kaushik Bhattacharya confidential section presently under suspension did not inform the commission that his sister is a candidate of WBCS examination 2017 as mentioned in the article of charges is established. Therefore, the charge framed by PSC under article of charge 1 against Kaushik Bhattacharya confidential section presently under suspension is established. So now his question that it is not reasoned, Lordship, the inquiry officer has given all the reasons in support of his finding.
Yes.
In respect of charge 1. Coming to charge 2. Shri Kaushik Bhattacharya, presently under suspension, admitted that he was attached to confidential section of the Office of Public Service Commission, but in his deposition before me on 4th July 2019, denied that his duty was to process and data received from HON'BLE and other computer agencies for tabulation and preparation of merit list in different stages of examination. So there is a contradictory statement here. He admitted that as per prevailing system, he had free access to the email of Deputy Secretary where the result of different examination was received from Webel. This is the admission. Different examination. Also submitted that we had access to the email of the secretary along with several others, including PS and AS themselves. He also admitted that we said email of every secretary. It is defined as registered by number and used the said email for his personal purpose and admitted and submitted that which I'm not taking, though I'm not taking.
Yes.
Papers as was received from Webel and submitted he was not in any such charge, which is again contradictory statement, Lordship. He further submitted that he was not in any charge of processing data received from Webel and other computer agencies for tabulation and preparation of merit list in different stages of examination. Processed the marks of 6 compulsory and 2 optional papers as was received from Webel for WBCS examination 2017. But he submitted that he was allotted and entrusted only with the work relating to holding of personality test and preparation of result of group A and B services. That he had prepared the note sheet containing the tabulation sheet and merit list of group A and B, put his signature on the note sheet, which was mandatory, and signed the self-defense. He submitted that the final tabulation sheet of the instant examination was prepared and furnished by Webel on 12th June 2018 via email ID of Deputy Secretary, and the list of candidates to be called and the program of was drawn up on the very day by a team including himself and 2 IT experts from Webel. Shri Bhattacharya, in his self-defense statement as well as deposition dated 4th July 2019, denied that he generated a working list in hard copy from the computerized data with the candidates to be called for the personality test of Group C services.
Yes.
He further added that he was not in charge of any work related to Group C and he had no business or opportunity to encroach upon the responsibility of Kaushik Saha and Shrimati Karuna Mollik, who were the designated dealing assistant, whereas we have seen that he was the only person who has downloaded the data and hand over the same to the dealing assistants. He also denied that he has prepared a detailed program of personality test of Group C of the said examination, and accordingly the candidates were called to interview.
Yes. So sufficient evidence were available. Actually, a read court cannot sit in appeal.
Yes,
It's
Lordship.
not appeal.
That is why
A
we are not
scope
going
of
into the depositions.
appreciation of the evidence in disciplinary proceedings by a read court is very limited. Only when any allegation will come, the decision is based on no evidence, then only for a limited purpose, the court may enter into the evidence. So court has entered into the evidence, and as your case is that the sufficient case is available, sufficient material or evidence was available. Mr. Roy will say no, that the decision, there was no evidence at all. He has said the purpose. Evidence at all.
And also, Lordship, I would like to place from my affidavit in opposition how the scheme of examination, how it was related, each groups, how it was related, and I have dealt with the allegations he has made in the each and every paragraphs of his petition. And Lordship has also seen that he has disclosed one new document of note sheet in the reply. In that respect, also I have received an
Actually, scope of I have immediately which I have expressed what was thinking was passing in the
it
mind
is
of
not
the court
admissible document.
that yes, it has not been brought on.
Like to place
It
that
has not been
genuine
brought on record.
authenticity of the documents, Lordship, how it is how differentiated from the file, Lordship. That I would like to place. Lordship, I need only 1 hour time, Lordship, to place. Lordship, kindly allow me, Lordship.
No, that's enough. Yes, you have done very good. That's enough. 1/2 sufficient. Otherwise, no matter. Sufficient. Disciplinary proceedings, actually, it is not an appeal. It is not appeal. It is only for the purpose, for a limited purpose.
While passing
You
the
know,
order, kindly
numbers of judgment.
kindly consider
As one lower one subordinate court has convicted or acquitted in a criminal appeal or civil appeal, as we sit in appeal, that is another. Then line to line evidence would be scanned. Whether such fact has been proved. There are bundles of facts, where every fact which has contributed to the chain have been proved or not. That is here only a limited purpose, whether sufficient evidence were available on record or not. That's now another fact is that he has claimed that punishment is disproportionate. If proportion is to be maintained, punishment must be commensurate. Now, what is your submission on this? He is saying that punishment is disproportionate. Even if it is proved, he has failed to prove that he has given such intimation, or even it proved that he got access to the data of group C and D, but punishment is disproportionate. Whether dismissal from service is proportionate to the misconduct committed by him. Then doctrine of proportion will apply. If anyone assault any person with Christian blow, he cannot be sent to the given to the life imprisonment. There must be some proportion.
On this score, I need some time.
Not this way. Hey, so much time cannot be.
That you have heard me for a long
No.
time.
You have done. You have done that. The court will take care of. Okay. And what judgment you want to see? Want to rely upon? What judgment you want to rely upon?
About this, my lord, my lord Justice Ganguly's judgment, my lord, 2010.
2010 or what?
496.
Yes. Yes. Give it.
So here, my lord, paragraph number 40.
I got occasion to rely upon.
Yes. Keep. Paragraph number 47.
Yes. That judgment is the predetermined mind.
Yes, man. Yes.
From the so-called, from the charge sheet itself, if it appears you have already determined that he has committed the offense or he has committed the misconduct. Okay, give that judgment.
And apart from this, my lord, this judgment, my lord, which says that the disciplining authority's order also has to be reasoned. My lord, the paragraph number 47 of this particular judgment.
Yes.
May I just write the paragraph number?
Yes, paragraph number.
Grateful. And my lord, my learned friend, my lord, has my lord, tried to explain, my lord, the word evident by saying that there was this particular word has been used after they were satisfied by the inquiry that this gentleman has committed the offense. This is why the word evident has been issued. But this is a charge sheet. which is-
No, it is not.
this is
Kanti
my-
associate, no.
This is with respect
Okay, it is also what I am trying, I was trying to say oxy such and such, that is also.
I know, my lord, I just hand up to your lordship, my lord. And also-
No, I have not to hand up. I have referred this judgment on several judgments. I am saying, trying to find out. That is also authored by Justice Ganguly. Yes. Yes.
That is all.
Hmm.
But he tried to, my lord, my learned friend, my lord, tried to say that using the word evident after being satisfied on an inquiry. So, my lord, I do not know anything about any preliminary inquiry, if at all, has happened before the submission of this charge sheet.
No, they have not relied upon. They have not referred any preliminary inquiry.
He said that immediately after being satisfied of the inquiry, this charge sheet has been issued. So this is why I said I did,
Difference in the marks, I have said it. Difference in the
this, I
marks.
did not get any opportunity to this preliminary inquiry, whatever. At all,
I
it
never
is.
said any preliminary inquiry.
Okay, if the rule is that if you, what Mr. Rai want to say, if you conduct any preliminary inquiry and if you rely upon any preliminary report, you have to submit, supply the same to the delinquent employee. Okay, it is the
Lordship, in respect of
Huh?
in respect of the question of proportionality, Lordship, I would like to place a judgment, though the copy is not with me, I shall supply it to Lordship.
Yes, give it my officer.
2008 7 SCC 580.
Huh?
2008 7 SCC 580. The Supreme Court observed that while considering the question of proportionality of sentence imposed on a delinquent,
On proportionality, yes.
the conclusion of the departmental inquiry, the court should also take into consideration the mental setup of the delinquent, the type of duty performed by him, and similar relevant circumstances which go into the decision-making process. If the charged employee holds the position of trust where honesty and integrity are inbuilt requirement of functioning, it would not be proper to deal with the matter leniently. Misconduct in such cases has to be dealt with iron hands.
Yes.
And the next judgment, Lordship, 2006 3 SSC 276.
Yes.
The Lordship
Our earlier judgment 2008 volume 5 SCC page.
2008 volume 7 SCC.
Yes.
580.
580, yes.
And the next is 2006 volume 3 SCC 276.
276, yes.
I shall hand over the
Yes,
Lordship, the copies of the judgment. The Supreme Court held that it is not well settled that the principles of law that the High Court or the tribunal in exercise of its power of judicial review would not normally interfere with the quantum of punishment. Doctrine of proportionality can be invoked only under certain situations.
Yes.
It is now well settled that High Court shall be very slow in interfering with the quantum of punishment unless it is found to be shocking to one's conscience.
Unless it is found to be
Shocking to one's
shocking,
conscience.
yes. Unless it is found to be shocking. And so the word so outrageous or contrary to logic, very good word has been used by the Supreme Court. Yes.
I shall hand over the judgments, Lordship. And I'm grateful for giving me patience hearing.
Okay, yes. That's all.